My lord, may I have a lordship leave, my lord, to move this, my lord, writ petition, my lord, tomorrow, my lord, because, my lord, this matter pertains to, my lord, that, my lord, where, my lord, 10 marks can be allocated, my lord, before prior teaching staff, my can this be order, my lord? My lord,
Whose order is this?
my lord, your lordship's order.
Let it remain. Thing is, I have already fixed a batch of matters. Let it be taken up.
My lord, tomorrow this matter is fixed, my lord.
This matter is fixed means you have the writ petition in your hand.
Yes, my lord, connecting to this, my lord,
File it in the department.
my lord, kindly, your lordship, my lord, kindly,
Sir, any order passed in that matter will cover your case also.
my lord.
So,
But my kindly, my lord, let it be, my lord, give leave, my lord, to move tomorrow, my lord, along with that writ
no,
petition, my
sir.
lord.
No.
My lord, the one motion, new motion, somehow it has been, my lord, misplaced. It was in the list on 27th October 143. But now I searching, my lord, the matter has been gone down in the department. New motion, matter has not yet been taken up. My lord, the higher scale of pay, my lord, for consideration, matter is pending.
How can new motion go down in the department? ও লিস্টে ছিল না?
এই যে লিস্টে ছিল স্যার 143, it was in the
Previous list.
previous list.
Oh, that is the reason. So you want inclusion, not
Well, this is higher scale, but only for consideration. Matter is pending. Your lordship, the other matter also, my matter and my lord, the Mr. Moitu matter fixed. Probably, well, the next week, my lord, the higher scale, my lord, the
mention next week. This
The correction, my lord.
correction give. No inclusions. Please do not mention for inclusions.
On the day of disposal, I appeared with your lordship on behalf of the state police, but my name has not been recorded in the order.
And in the second, if you would have mentioned, consider file and keep the number. Let it appear tomorrow. In this connection, I have given notice. Or
The commission council remains here every day. Next week. All right, next week it will be seen. This week. Tomorrow, let us see what happens. I do not know.
Monday, the document verification will be concluded. That's the whole trouble. That's why I mentioned to lordship date to study. Having urgency, your lordship can't say no, sir. Give notice to the Mr. Nath and let it remain.
What will happen to the examination? Nobody knows, and you are running after document verification.
Regarding 10 marks, I am not in a.
Yes, so please wait.
Madam,
Nothing.
may permit to mention for a correction.
Correction, no. Next week
Correction
mention.
for a typographical error of your lordship.
May be permitted to mention Millard item number 350 to 354. Millard, in this matter, Millard Bhatpara Municipality appeared on last occasion, that is Millard 18th of September, and also Mr. Shivshanno Bandopadhyay to Devento.
Then what happened?
The lordship was pleased to direct both of them, Millard, to mutually sort out the source of the payment so that the petitioner, Millard, petitioner's bills are cleared, Millard, at an earliest. Millard, the matter was, Millard, due to appear today. Millard, out of turn on last occasion, your lordship was pleased to take up the matter. I have already served notice upon them, Millard. If your lordship kindly take up the matter at any time, Millard, I will again inform them.
The matter is there in the list today.
Yes. 350 to 354. No, ajker list.
Contempt.
Contempt.
Yes. But then, has it been resolved?
Millard, that I do not know. Nothing has been informed to my client. Whether they have, Millard, already, Millard, let them say, Millard, before your lordship. Otherwise, Millard, since 2014, now Millard 2025.
You bring your other side. File gulo ekটু রাখবেন. Bring your other side. Prior to, no, 3 p.m. prior to rising.
Prior to rising. I'm intimating.
May I allow to mention one matter? Correction give. May I allow to mention one matter? Matter is an urgent matter. It's in the heading of inclusion, lordship. So, inclusion? Why? It's an urgent matter. It's an old matter. Microphone. It is an old matter. How old? The matter is of 2022. How does the urgency crop up? It's a change brief, lordship. So it's because of the change the urgency cropped up. Then what? What is the urgency? Urgency is The petitioner is suffering from orthopedic disease caused with neurological problem since the month of June
Don't look at
2023.
it. Say what is there.
2023, whereby she is facing substantial problems, is
Let him
undertaking.
take medical help. Why are you here? Why are you here? There must be some reason why are you here.
Exactly.
Yes. What is the reason?
The reason is just because of his disease, it is very much problematic for her to go to her workplace and come back in her home.
Yes.
It's a long journey, and
So what
she
you
is not
want?
able to.
What do you want?
Kindly keep this matter at any date, Lordship. Kindly
Yes,
keep
that I understand. What is the prayer in the writ petition? Transfer.
Probably that's
Exactly.
the word. I mean.
Not probably. It is
transfer.
From 22 to 25, the transfer matter is pending.
Exactly.
Isn't it?
Yes.
Come next week. All right. And check up whether the prayer is for transfer or something else.
Okay. Okay.
All right.
With my lord's kind leave, my lord, this matter, contempt matter, my lord, this was taken up on last two occasions. The chairman of the municipality was called, my lord. My lord, they undertook that they will be filing an affidavit of compliance, my lord. If your lordship kindly recalls, this pertains to a matter where a common passage was blocked by building a construction over there, my lord. Till date, my lord, they have not yet complied. They called the client for one hearing, but thereafter no reasoned order has been passed, my lord. Rule was also issued, my lord.
Contempt matters are
Kindly
my
up-
action. Right? If I keep upgrading, the list will be shuffled.
Your lordship only
Slowly.
takes it up on
Wait.
Thursday.
Yes.
Mention for inclusion one contempt application.
No, nothing.
226 in today's list for non-prosecution.
If
I beg pardon to mention, your lordship knows very well, but there is grave urgency since the document verification process started from 18.
give.
My lord.
May I permit it to mention?
Yes.
Item number 148. I have already informed the
Just wait. I
May
cannot
permit to
accommodate.
mention two matter, my lords, for restoration application.
What inclusion?
No, my lord, running in the list.
Yes.
273 or 365. Now, one of the transfer matter, another is the higher scale of pay.
Yes.
But may I bring the other set?
No, please don't bring.
Right.
Yes, call the list.
And for the added response, this was probably disposed of. It's reported in SCC online.
Suppose হয়ে গেছে? আচ্ছা, জিএটা পড়ে আছে। হ্যাঁ। এদের কাছে কোনো
GA, I was one of the added respondent. This was a challenge in regard to the
is here
GA. I am not aware. We were not even served with the GA.
not even served.
But the GA is of a date which is prior to the disposal. So
Obviously. ঠিক আছে, তাহলে ওই সেম অর্ডার করে দিন।
okay.
1 and 2 same both.
Let's start taking number 1.
Correction to be mentioned. To be mentioned, Mr. Shubhra Prakash Lahiri, Rajesh Noshkar, Ankon Mondal. Correction? What is the correction?
The typographical mistake, my lord, the petitioner, my lord, the Mousumi Pal, MOUSHUMI, but my lord, the actual name is MOUSUMI.
Late by Mr. Rao. MOUSHUMI.
My lord, there is a mistake on my part due to importance. This H has been printed. kindly leave may be granted to correct the cost title. This age, at my instance, it has happened, my lord, because I have this due to inadvertent, instead of S, H has been put, my lord.
এটা লিভ দিলে তখন ওটাও চেঞ্জ করতে হবে।
এস এর পরে এইচটা ঢুকে গেছে।
H টা ঢুকে গেছে। But in the affidavit page, she has signed as S. That is due to typographical error, my lord, it has happened.
It has been brought to the notice of the court that আগে ওটা কিন্তু লিখবেন যে matter has appeared in the list for correction, হ্যাঁ, list that the name of the petitioner has been wrongly spelt in the cause title of the writ petition. Stop. The proper spelling of the name of the petitioner will be Mousumi. H টা হবে না, ঠিক আছে? The name of the petitioner appearing in the order dated 21st November 2025 shall also be changed to Mousumi. এই যে সই করেছে তো, সেটাই তো দেখলাম, সইটাই তো দেখলাম। হ্যাঁ, এই তো সই করেছে। যে সই করলো সেও দেখলো না যে এখানে এইচটা লেখা আছে। হ্যাঁ, আমি দেখলাম তো।
Lord, I am for the petitioner, my lord. The petitioner before your lordship are in-service teachers. In the 25th SLST, my lord, following written test, they have been called for interview. My grievance in this means that model key answer prescribes that D is the correct answer. We answered it at the D, but at the final, it has been changed and it has come to B and C.
D has gone out.
D has gone out.
All right.
This is the case about. After that, my lord, we represented the authority, no action taken. Paragraph 7, my lord, will get entire case has been read out in paragraph 7.
Doesn't matter. Commission. In the preliminary, it was D.
It was D.
And in final, it has
Finally,
changed.
it has become B and C.
Yes.
Instruction goes, he has not made objections in the first instance.
It was not required because his answer was correct.
My lord, I am appearing for it, my lord.
Yes.
Sorry for it, my lord. Sorry. But, my lord, this is correct that he has not raised objection because whatever initially it was given by him, that was correct. But thereafter, the expert committee said that this was not correct. Others raised objection. Accordingly, my lord, that has been changed. The correct answer. That is the position here. Initially, what he has written, that was correct according to us.
Then that means something is wrong somewhere. Your preliminary answer key gives the right answer and then somebody else.
Yes. Some raised objection, naturally that has to be decided by the expert committee. That expert committee has been constituted for that. Expert committee has...
I understand. That means your professors or whoever are the invigilators, they also do not know what is the proper answer. Then how could at the first place the answer D could have been made to be proper?
My difficulties are this, only difficulties is this. Subject to your lordship's permission, can I suggest, my lord?
Certainly.
My lord, this answer should be treated as right by the SSC.
You take a call. It is your commission. It is your professors, your experts. Everybody is yours. The court doesn't know the answer, neither the question.
My lord, then in that case, my lord, kindly give me some time. Let me.
Yes.
And also, if required, my lord, we will file an affidavit, short
For
affidavit.
what?
For this purpose.
saying that the answer that the petitioner wrote is correct?
No, that the answer which was given to by him in the that preliminary was, according to us, it was correct.
That means
Now some persons have raised objections. There are objections were raised from different levels. Then these objections have been sent to the expert committee. Then whatever the expert committee has decided, that is not binding on us. Rule says so.
yes, certainly. Can't the commission frame questions in such a manner that the question have a definite answer? One question has got 10 answers, you give marks to one and you do not give marks to the other. One professor says it is right, the other says it's wrong. What is happening? When
Well,
do you propose to come back?
Well, I will come back within 7 days with an affidavit.
And in the meantime, I do not know, verification or something, y'all are.
Fourth is verification.
Fourth is the verification, the petitioners say.
Well,
Fourth is Thursday. In that case, we can fix it on Tuesday? Second?
Well, in that case, well, subject to the result of the applications, let him be allowed to appear in the verification.
What is the order passed by the Honorable Supreme Court yesterday? Can I have a copy?
Lord, Supreme Court, no copy, we have not got
Yes,
it.
not
I
yet.
just, can I just say, Supreme Court has sent all matters back to your Lordship's court to
Yes.
decide. All issues to be decided by your Lordships.
Right.
This is the main thing of the order.
Then
And
the rule
there-
itself pursuant to which the examination is being conducted is under challenge. So till the rule is found to be in order, the examination cannot proceed, or at least I do not know what's going to happen. The submissions will come up from
No,
your
that
side.
is different issue, my lord. But your Lordships will decide all the questions.
Right.
That your Lordships will decide all the questions. That is the Supreme Court has said yesterday.
All right,
And
to
another one or two findings have been given, but that I can't recollect now, unless the order is there.
Yes,
But
yes.
everything has been sent back to your Lordships. Lord, may I just, your Lordships, subject to your Lordships permission, Lord, approval, Lordships can pass an order that subject to abide by the result of this writ petition.
All right.
Let him appear
How
in
many
the
are there?
verification.
How many petitioners? Six petitioners. All answered D.
No, all answered D, my lord. Lord, only one question, Lord. Petitioner number 1 to 3, I am saying, Lord. Concerns with A series question number 9.
Yes.
And petitioner number 4 concerns with question number 23 and 4 and 5, 23.
No. Thing is it the case of all the petitioners?
Same question, same answer.
The petitioners participated in the second SLST.
How much
Where
number
is
is
the
there?
deficit court fees? Deficit court fees. 6 petitioners are here. You've given only one court fee.
I will be paying, Lord. Will be paying. I undertake to pay.
Participated in the second SLST, 2025. Stop. Now they found that the answer which they marked in the question paper was tallied with the preliminary model answer key that was published by the commission. Stop. After publication of the final model answer key, the answer got changed. Stop. The petitioners are aggrieved by the same. Stop. It has been submitted that the petitioners did not have any scope to file objection as their answer tallied with the answer published by the commission. Stop. It is only after publication of the final result that the answer got changed. Prayer has been made to treat the answer of the petitioner as correct. Stop. Learned counsel representing the commission seeks to revert with instruction.
One statement may kindly record that all they are above the cut-off marks.
How does it matter?
No, otherwise they will get the chance to appear for the verification.
It has been brought to the notice of the court that by the learned counsel for the commission that all the petitioners scored marks above the cutoff marks for which they would otherwise be eligible for interview
Verification.
and interview and credential verification.
And they have been called for.
Stop. The petitioners have been called for the interview, which is scheduled on 4th December 2025. Stop. Paragraph. As it
But if
appears
they are
that
called for interview, in that case, verification is over.
No, it would be on 4th.
Then
is it
verification.
interview or credential verification?
Both.
Credential
Both.
verification.
Both.
Oh, interview and credential verification. Acha, next.
Verification.
কি বললাম?
Interview, no.
Right. Right.
No, not, I stand corrected. It is for verification.
Not interview, verification. Credential verification. ইন্টারভিউটা হবে না ঠিক আছে as it appears that the answer given by the petitioners was found to be correct at the initial stage. Accordingly, let the petitioners be permitted to participate in the credential verification process. Stop. The marks that may be awarded to the petitioner if the answer is found to be ultimately correct shall কি দিয়ে শুরু করলাম
marks
হুম
may be awarded to the
হুম
if the answer is found to be ultimately correct.
Will be added at a later stage. Stop. The fate of the credential verification and subsequent steps in the recruitment process shall abide by the result of the writ petition. Stop. Release the matter for further consideration on. When do I keep it? 4th? Next Thursday? Today is Thursday. 4th. A written report from the commission shall be placed before this court on the next date. Service is taken on record. Leave granted to the advocate on record of the petitioners to submit deficit court fees in respect of 5 petitioners in the course of the day. Next.
Item number 3,
my lord, I am for the petitioner, my lord.
the identical matter is fixed
No,
tomorrow.
my lord, not at all identical, not
For
at all
tomorrow.
identical.
I have the
Let me
prayer.
place my case, my lord.
My lords, it's identical, if I may, my lords. Good morning, my lady. This
Yes, my
matter
case.
is listed. Your ladyship is seized of these matters tomorrow. Identical
This
matters,
is
and
your
now the
lordship's
Supreme Court
order.
has also made clear
Identical
that your
prayer.
ladyship will hear all the issues that my lady has specified in her set of 3 orders. So now everything is before my lady, and an identical petition, Kiran Deb Sarma, WP 22447 of 2025, is pending before my lady, which is listed to be heard tomorrow. And I will also have the pleasure of being there physically, my lady.
But I appear for the state. I believe all these matters can be taken up together tomorrow.
This is the prayer.
I have my objection.
But I am appearing for this school service commission.
This is the prayer. If lordship fixes, this is the same prayer.
My lord, your lordship, no, tomorrow.
Yes, what is the matter?
My lord, the matters is, my lord, your lordship has held, my lord, the division bench of our High Court twice and the Supreme Court that no tainted candidates would be allowed to participate in the recruitment process, in the written examination, If any candidate slips through the net, my lord, the commission will ultimately reject their candidature after verification. My contention is, my lord, though a list has been published which only contains the name of the candidates, my lord, who have Weimar mismatch, their name has been published as tainted candidates. My contention is, my lord, none of the names who have been appointed after expiry of the panel are being included in the list of tainted candidates. Now, why I am saying expiry of panel is falls under the list of tainted candidates. Well, straight away come to this, my lord, the judgment of the division bench in the first round, when, my lord, our division bench set aside 26,000 appointments. My lord, page 260.
Page 260.
Page 260, my lord. Paragraph 14. Paragraph Roman 14. My lord, paragraph 335. It is paragraph 335 and paragraph, my lord. So,
XI?
yes, appointments given to persons submitted, and, my lord, XI. Appointments have been given to persons after expiry of panel. So, my lord, this is one category which falls under the tainted. Now, my lord, a writ petition was moved immediately after the advertisement was issued that no tainted candidates will be allowed to participate. But the coordinate bench allowed our prayer, saying that no tainted candidates should be allowed to participate. Very interestingly, my lord, the state and the commission preferred an appeal, saying that no tainted candidates should be allowed to participate. Now, my lord, the division.
Preferred an appeal where?
Before the division bench.
All right.
The tainted candidates should be allowed to participate. My lord, kindly come to paragraph, my lord. No, I place from, my lord. Paragraph 30 onwards, page 21.
No, but then the Supreme Court has made it clear that the tainted candidates will not be allowed.
Yes, my lord. Why I am placing this, my lord? Tainted will not be allowed. Why they might say, my lord, expiry of panel. Why I am saying so, my lord? This is important. This is the division bench judgment, and it's probably nothing else. My lord, truth has an ugly habit of raising its head, and when it raises its head firmly, it engulfs and demolishes any system which is founded on deception and corruption. In the earlier round of British.
Don't read. Tell me what.
Then, my lord, kindly come to page 23, paragraph 32.
Yes.
Paragraph 363, Roman has classified three categories of candidates who can be described as tainted candidates. Persons who have been outside the panel, my lord. Thereafter, persons.
Expiry of the panel.
Expiry of the panel. Now, my lord, my contention is the list, and, my lord, your lordship is already aware of the 28th August and 29th August Supreme Court order, where it has been, Supreme Court has stated that no tainted candidates would be allowed to participate in the recruitment process. Now, my lord, kindly come to order of the Supreme Court at page, my lord, 61 of the recruitment.
Yes.
WBSSC has also tried to justify the extension of the term of panel.
Yes.
Above, the time period of 1 year specified in Rule 21 of the Rule 21 for destruction of Weimar coincides with the time period specified for validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teachers for 19 and 12 were made after expiry of panel. This is illegal and contrary to the rules. Reliance had been placed on the orders of the High Court, which clearly the cases of rank jumping, where the High Court directed to appoint candidates after expiry of validity of the panel would not have any significant impact. Now, my lord, clear that after expiry of panel, nothing. Now, my lord, kindly come to paragraph 10 of my.
The panel, the list of tainted candidates that has been published, there is no mention of anybody.
Because there is no mention of under which category they fall tainted.
Yes.
And, my lord, these petitioners submit on oath that none of the names which included in that list contains after expiry of panel. That is why all of these addition of party applications are floating in before your lordships. My lord, now kindly come to paragraph 10 of my writ petition. This is at page, my lord, page 12. Lord, I'm reading this sub-paragraph. It is pertinent to mention.
Yes.
It is pertinent to mention here in that the panel for classes 11 and 12 was published on 27/11/2017 and the same expired on 27/11/2018. And the classes for 9 and 10, it was published on 12/3/2018 and the same expired on 12/3/2019. It is further pertinent to mention herein for both classes 9, 10 and 11, 12. 2 rounds of counseling had been conducted within the tenure of the panel. There were 7 or 8 rounds of counseling. After second round, all counseling and appointments were made after expiry of the panel. And my lord, the Supreme Court has categorically stated in paragraph 31 that counseling and appointments made after expiry of panel is illegal, and the act of the commission in trying to extend the panel is also bad in paragraph 31. Now, my lord, my prayer before your lordship is the list, they should include the candidates who have been appointed after second round of counseling for 9, 10 and 11, 12, and the list should contain the category under which they fall. Otherwise, this will contain.
Category means?
My lord?
Category means what?
Category means, my lord, whether they are falls under rank jump or.
All right. All right. All right.
Except court orders.
And why this is urgent, my lord? The 11 in the Supreme Court, it was stated that nobody would be allowed to sit in the written examination. They have been allowed. They have been now called for verification. Their verification, they have not been rejected. Now 9, 10 results have been published. They have been included. So, my lord, in this way, now they will say interview will be done. Now my right has accrued. Nobody has challenged it. Again, my lord, this chaos will happen.
All right. Then in that case, commission's list was placed before me on one occasion. Is the list there?
Well, there is an important aspect in the matter which may have.
I want to see the list once.
I have the list.
Let me see once.
But in that list, it was not there.
Do you have any other list?
No. Only one list.
Only one list. Where is the names of the candidates who were called for counseling after expiry of the panel?
Well, I just tell you. But if your lordships kindly see the judgment of the Supreme Court.
No, I want to see the list. The list, it must be there in that bundle, isn't it? Is it there, Mr. Bandyopadhyay? The list was there, isn't it? Yes, please, let me see. What are the heads over here? Heads are mentioned?
Heads were mentioned in the very Supreme Court judgment itself.
Where? Which portion? 292?
325 onwards, your lordship will get the status.
292 is the list.
325. 292 is the list.
List of all candidates as per notice number such and such. All candidates, what does all candidates means? How many candidates participated in the examination, or what does all candidates mean?
All candidates who have been asserted to be tainted.
Why have you not mentioned it? List of tainted candidates?
325 candidates onward, the status of each candidate has been
325. When you publish a list, you mention it as, I don't know, commission. You are not there for the commission.
No. We have given a notice on 30th August 2025.
325. List of tainted candidates with nature of taint. OMR issue.
Out of panel is mentioned from 340.
Rank jumping.
Also mentioned as indicated.
Out of panel.
340.
340, 341, 342. OMR issue. Is there any candidate where it is mentioned called for interview or counseling after the expiry of the panel? Nobody is there. It cannot be. It has to be because court has found that there are candidates.
That finding. But my learned friend
to that extent, Mr. Bandyopadhyay was advancing argument.
That has been diluted by the Honorable Supreme Court in other paragraphs, where specific on the basis of the CBI report, a table has been, my lord, copy pasted.
Wait. Yes.
Well,
Senior
can I
Mr.
make,
Bandyopadhyay.
yes, can I make a submission? Kindly, my lord, come to, my lord, the page 56.
Yes.
Page 56 of the writ petition. Lordship will find, my lord, paragraph 24. The impugned judgment refers to the following statistical report submitted by the WBSSA before the High Court. This is the OMR issue, rank jumping, alleged irregularity. Alleged irregularity, so and so, percentage. Then we will kindly come to paragraph 25. In the written submissions filed on behalf of the WBSSA in the court, two tables have been furnished. Table 1 pertains to the candidates who either jump ranking or were appointed despite not being in a panel. Their details are as under this. Then we have table 1, table 2. The losses will find there no kind of a, but those who are found tainted by the CBI, on that basis, this was prepared. This was done. They are the tainted persons have been found by the CBI in their report. Now, others have not been found as a tainted person. Now, if the
Where
others
are the candidates who were found to have been called for interview after expiry of the panel? Is there anything mentioned anywhere? Because the
no,
court's
it was
order
not.
mentions about that.
It was not the case of anybody before the Supreme Court. Today, a new case is being made out. Things.
Our Supreme Court has remanded the matter here. Whatever was under remand is different. This is absolutely fresh writ petition that has been filed. And the allegation is that candidates who were found to be called for interview or verification or whatever, it was after the expiry of the panel. This fact of expiry of the panel was taken note of by the division bench of this court, and it was affirmed by the Supreme Court. I want to see the list which contains the names of those candidates who were called for interview after expiry of the panel. This is what the court wants to know.
My lord, just in the gist, I submit. After the counseling of third panel, up to counseling of the third panel, this list was, the panel was valid. But during 1 month, 1 year, 6 months, there was an interim order on the panel. Thereafter, so many matters have been moved. There, the court has allowed to work on that. I have the orders also. Now, therefore, the counseling process has begun 1, 2, 3, 4, 5, 6, 7, 8. But it is not that these panel candidates have committed any fraud or any other things, like the tainted candidates. Now, therefore, the up to 8 council, this process was continuing. It is a part of the process. And they have been, still now, they are not being treated as a tainted. Therefore, they have been asked to appear in the examination. They have been asked to appear, those who have succeeded, to appear before the interview.
The division bench of this court found the appointments given to persons after expiry of the panel to be an illegality. That is what is mentioned in paragraph 335 of the division bench's judgment.
Yes.
Right. So
Right.
if an illegality has been committed, that cannot be perpetrated.
That has been merged with the Supreme Court order, that finding.
Exactly. After merger, this becomes valid. The division bench's order gets validated.
Now,
Court,
we'll go by the Supreme Court's order, my lord.
yes, certainly.
Anyway, whatever the way you also decide, we don't have the difficulties with that. This is our stand, we have said so.
Your stand is clear. Please show the candidates who fall under category 335 XI of the division bench's judgment.
No, we have not treated them, this panel, when the counseling was going on, when the process of counseling was going on, we have not treated after third counseling The panel has expired.
Appointments.
And they are still continuing in the employment in view of the Supreme Court's order. Their appointments also have not been challenged by them.
Submission was made before the Supreme Court when this matter was being heard.
Their appointments have not been challenged.
Line of paragraph 31.
Supreme Court judgment.
Supreme Court judgment, page 61 of the writ petition. First line. These very submissions were made before the Honorable Chief Justice Justice Khanna as his lordship came on. And kindly see, WPCC has also tried to justify the extension of the term of the patent. It was justified, tried to be justified, it has been rejected as illegal and bad.
Well, this has to be read with 46.
একবার বলে দে, this is illegal and contrary to the rules.
Yeah, what
It has to be read with 46. Right.
Yes.
Found to be tainted.
No, there is a difference
Not
between
specifically.
for candidates not specifically found to be tainted.
Right.
Now there are separate tables which have been provided in the very judgment itself. If lordships kindly have a look at that. Just may I say, well, this will have a there are large number of persons. Even we are getting salary. We are also, my lord, providing employment. Kindly look at this. No, may I just say, kindly visual. May I kindly visualize. My lord, kindly look at from a point of view of a very surface that any illegality is tainted. That argument is possible. But there is a likelihood when lordship look at the entire judgment, the Honorable Supreme Court used the word tainted for exactly categorized persons. Now that exactly categorized persons, they lose any right to participate in the further selection process. Now that categorization was done by the Honorable Supreme Court on the basis of fundamental two things. Thing number one, 4 reports filed by the CBI, because CBI scanned all the OMR sheets. And thing number 2 was the affidavit filed the SSC. What exactly happened was that, well, there wasn't, I take it, 1 year validity of the panel. Absolutely true that after that date, there has been counselings up to 8th counselling. That is true. So if lordship ask a yes or no questions like a mathematics, then the answer would be yes. If starting, there are a couple of counselings which were after the 1 year expiry, correct? But does it mean that those persons who were appointed and who never participated or never been part of this Weimar, that corruption part, are they tainted, or whether the Honorable Supreme Court wanted them to be included in the tainted or not? That this has a larger issue. We also need to, may I say very honestly,
Why don't you get it clarified by the Supreme Court what the court wants?
the Supreme Court has clarified. That is the reason the Honorable Supreme Court completely dependent on the basis of the list by the SSC and allowed all of us to get the salary, and we are serving.
You are serving
Yes.
because of the benevolence of the commission.
No, we are serving because, correct, I take it that benevolence of this.
Somebody is there online,
I
can make submission, otherwise you will be scolded by somebody else and not by the court.
It is our life and death. It is our life and death.
May I make one line submission?
All I say this, I have only one thing to say. This is an extremely important issue. May I only get 1 day? Only 1 day. All I sought that tomorrow, so that we can also take all preparations. Because there are large number of
kindly read
matters.
the paragraph 46 for this. Everything has to be boiled down in paragraph 46 of the judgment. 46 of the judgment.
after expiry of panel, and also those who submitted blank OMR but obtained appointments must return all remunerations and benefits received by them. Now read paragraph 45. This is the division bench judgment. Now read paragraph 45 of the Supreme Court judgment. This is at page 67. The last question, your lordship.
Yes.
The last question relates to the relief and whether it requires any modification. We had no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates whose appointment must be terminated and they should be required to refund any salary payment secured since their appointment is a result of fraud. These amount in cheating, they have to seek for justification to alternatives. So, my lord, kindly read this with 363.4 and this paragraph. Nothing remains, my lord. All these things were already submitted and Supreme Court.
Let me hear what the AG has to say. AG?
Milord, I have got a very short submission to make. But in my very humble understanding of the judgment of the Supreme Court, Milord, possibly, Milord, there were three categories of Milord candidates who were found to be tainted, which are number one, Milord, the candidates who were guilty of rank jumping or who were the beneficiaries of rank jumping. Number two is out of panel appointment. And number three, Milord, where Milord, the manipulation of OMR sheets had happened. Now, Milord, these are the Milord three broad categories of persons who were found to be tainted. Now, Milord, my learned friend for the petitioner today, Milord, wants your lordships to, Milord, add another category. The category being those who were appointed, Milord, after expiry of the panel. Please consider, Milord, whether, Milord, this can be done or not. Assuming, Milord, the allegations of the petitioners have any substance, please consider, will it not amount to adding to the judgment of the Honorable Supreme Court? The division bench had considered it, the Supreme Court had considered it, and Milord, this category of persons, Milord, in my understanding of the judgment, was not declared specifically to be tainted. Therefore, according to me, Milord, today, Milord, my learned friends cannot come out and try to make out a fourth category. Tomorrow somebody will come out and find out a fifth category. This cannot be added to the order of the Supreme Court. At this stage, Milord, this is my submission, subject to, Milord, consideration of, Milord, the judgments of the Honorable Supreme Court in its entirety, number one. And number two is, Milord, as your lordship knows, Milord, the Supreme Court has, Milord, fixed a timeline. The timeline being 31st of December 2025, which that process will be completed. Now, Milord, these kinds of petitions will pour in. This is expected that these kinds of writ petition, Milord, with some injury, this way, that way, will be portrayed before the court, seeking an interference. Milord, please allow the process to go on. If my learned friends can make out a case, that can be taken up, Milord, subsequently. But as of today, Milord, my understanding of the order of the Honorable Supreme Court is that, Milord, this fourth category was not treated as to be a tainted category by the Honorable Supreme Court, based on whatever, Milord, the report which was filed by the CBI, both by, Milord, our division bench as well as the Supreme Court. Let the process go on, Milord. We'll come back better prepared and, Milord, address your lordships on this issue, Milord. These are, Milord, my submissions for the present.
Milord, can I make one submission, Milord? Can I make, kindly allow me? Just allow me. Milord, the petitioners here, they have secured 34 and 24.
Yes.
Most unsuccessful persons.
Milord, I have
assume
been called for verification.
Not called for verification.
Yes, called for verification.
Very nice. Allow me to make submissions. Otherwise, my lord will be annoyed with me. You are interfering. But the 34 and 24. First of all, by no chance, even if the petition is allowed, they are not getting them. Their only purpose is, since we have not got it, no one will get it. This is one. Number two, Milord. Paragraph 46 has been said about tainted. Tainted is on the basis of the CBI report, it is tainted. Now, let's assume for the argument's sake, the appointments were illegal. Illegal doesn't equate to tainted. Tainted is based on a certain facts discovered by the CBI. The paragraph 46 has said about tainted, not illegal. There is a demarcation of these two. But this point needs to be argued. These points have to be argued. But this is initially I am pressing this point. Then we'll file affidavit. Lordships will decide.
And they will continue and they will again get there. Well, two things.
1 minute. 1 minute.
But I can show you one judge, one order. Just hand it over to Mr. Samim appeared. Now, one case they are obtaining one order, another case challenging. Kindly take the order of 30th August 2023. Give it Justice Vishwajit Basu's judgment. Salma Sultana.
Yes.
And see, the petitioner participated in the first SLST for recruitment of assistant teachers, so and so, sponsors, so and so. The petitioner was a waitlisted candidate in the sex selection process under the general female category. The petitioner alleged that in compliance with the direction passed in Sitabuddin, etc., a list of candidates was published by the West Bengal Board of Secondary Education, whose appointment letters were generated as per the recommendations of the West Bengal Central School Service Commission. And from the said list, the petitioner for the first time came to learn the commission had recommended her appointment in the post of so-and-so, and the board had issued the appointment letter. The petitioner thereafter has filed the instant paying appointment in the post she was recommended. Mr. Samim, learned counsel for the submit that it is astonishing as to how the petitioner was recommended for appointment in a particular school when she never appeared in any council. He further submits that 8th phase of counseling was done after the expiry of the life of the panel. Can you see? Then Dr. Patto, learned counsel for the commission, submits that a petitioner was notified to participate in the counseling through text message in her mobile phone, number of which she disclosed in her online application, but she did not turn up. He further submits that the intervening COVID-19 pandemic did not allow the commission to complete all rounds of commission councils within the period of the life of the panel. Mr. Bhattacharya, learned counsel for the board, submits that the appointment letter was issued to the petitioner on the recommendation of the commission by the so-and-so. Mr. So-and-so, I have heard the learned counsel for the at length and have perused the materials on record placed before me by the respondent authorities through their respective reports. The commission in its report has specifically stated that merit position of the candidates was not compromised in recommending the appointment of the petitioner. Holding the 8th phase of counseling after the expiry of the life of the panel gets justified for the situation which prevailed all over the world on intervening COVID-19 pandemic. The mode of notifying the candidates about the date of counseling through mobile phone in the member so-and-so, as has been argued by Ms. So-and-so, the possible candidate has missed such communication cannot be ruled out altogether. The petitioner was found to be eligible for the appointment but could not join in the process. Well, then the direction is that he should be there. Therefore, this 8 months counseling was already 8 times counseling was taken into consideration by your lord, one of the coordinate bench of your lordships, and their number of reasons one of the reason was COVID-19. But we can't go on, on just pure technical questions. We have to consider about the facts and circumstances of the case. More specifically, I am submitting, these persons who are not found to be tainted. Paragraph 46 is clear. That is only a tainted. Let's assume an order is bad. Order is bad doesn't mean it is tainted. Tainted where fraud has been committed.
Very well. Tainted, untainted, you please place the list of candidates who were appointed after the expiry of the panel. Whether they'll be treated as tainted or not tainted, it will be seen later on.
My lord, appointed in the second phase of counseling for 19 and 11, 12. That is
just one thing.
The division bench's order, whatever is there is there. Appointments given to persons after expiry of the panel. Let the names of these candidates be placed before the court.
Well, I have absolutely no difficulty for that.
My lord, that also,
Maybe
that
the
also
court
has
is
been
not going
covered by this
to,
paragraph 31.
there is a note, a mention in the division bench's order, which has been affirmed by the Supreme Court. This appointment be given.
Saying so. My lord, why I am saying so? In the
Well, we will see modified, rectified, clarified, whatever.
I am saying so.
Let the list
The
come.
second phase, because my lord, two things are important. The list of candidates appointed after expiry of panel and date of publication of the panel and date of expiration, the expiration of the panel. That may also be produced before your lord.
1 minute.
Otherwise, they will say my
1 minute. OMC tested. 1 minute. I want the list, Mr. Bandyopadhyay.
Yes,
From
my lord,
the
yes.
division benches order, page 260, 335, 335,
Roman 9.
Roman 9, appointments given to persons who were not there in the panel. 10, appointment given to person submitted blank OMR. Appointment given to persons after expiry. Persons placed lower in rank given appointments. That means rank jumping.
Well, accepting this Roman, that group regarding the appointment after expiry of the panel, other all categories have been treated as a tainted and their names have not been sent.
All right, the list that has been placed.
That is categorized list was there.
This list.
well, this is your lot.
1-9,
Kindly
Roman
see.
10.
So we have given the list.
This is little
Well,
thin one.
what
It can
tainted possibly is a very extremely, my lord.
Uploaded in the website, madam. But what thing, madam, in mostly Mandal matter, madam, pass the order. Till date, they not publish it. Full list is necessary. Madam, this Salma is considered by the Supreme Apex. In the volume.
Mosui Mandal is not taking up, Mr. Samim. The Mosui Mandal is not being taken up now.
But you refer the Salma.
No, refer the submission? Give the order first.
OMR issue.
And
Not in the panel.
That list.
OMR issue,
Rank
then
jumping.
out of panel.
9, 10 and 12
Out
is
of
already there.
panel.
9, 10 and 12.
9, 10 and 12 there. So 11 is not here.
Rank jumping.
only
11.
11 is not there, my lord. And
All right.
they have admittedly they are protecting those tainted candidates.
You may consider the what tainted is really what.
Yes, I see 9, 10 and 12 is there in whatever you have handed over in court. I do not know whether this is in the public domain or not. But then 11 is not there in your list also. Prepare a list and place it before the court.
Yes. All right.
With all details.
And my lord, one thing, my lord, at the earliest, because the verification, everything is going on, they will accrue their rights.
No, even it is stopped, you are not entitled to get for verification.
Yes, my lord.
Yeah. You have got only 32.
6,000 to 7,000. If these candidates go, automatically will come into
20,000 will go.
See one thing. The appointments of the year 218 also stood nullified by the Supreme Court in 2025. So it's not that it cannot happen. Rights may accrue, and then the court is here to see whether it's correctly accrued or not. So the court is taking care.
My lord, also
I
lord,
would
keep
like to
this.
see the yesterday's judgment, whatever is there, so that I understand.
My lord, also, my lord, kindly keep this, my lord, point open that whether, my lord, they can at all, my lord, come before this honorable court at this stage. My lord, at the time of, my lord, publication of the notice, they did not challenge, my lord, put this omission at least, that this is not there before the honorable court.
Where are you?
They're not yet published OMR sheet.
We are, my lord,
Kindly keep the maintainability point open, my lord.
by the order of this
Not
honorable.
published the OMR sheet.
My lord, till date, no OMR has been published, my lord. Details.
Then you participated in the test again.
Yes.
They hiding it, although
Yes.
Let us see what happens.
Yes, at least, my lord, kindly keep this.
I have
Well,
a
kindly
different
keep
point.
Keep this open, my lord. This is what I was just
All
suggesting.
is open. Nobody is closing anything.
Maintainability. No, maintainability.
After they participate, become literally unsuccessful, come before your lordships. Very nice.
these people not come forward, this scam could not have been
But this is
Correct, correct. Well, that is
These people were not the petitioner then.
yes.
maybe
Rather
somebody
we
else
were.
was.
Rather we were.
Someone else.
Somebody, you were. You
Rather
brought
we
this
were.
scam to the fore.
Yes, my lord.
So somebody has to come somewhere.
Yes.
Today A is there, tomorrow B will come, tomorrow's third day C will come.
But at
This
least,
is
my lord,
how it
our
unfolds itself.
entire endeavor shall be scam and the mere, if I can say, extension of panel possibly have been taken care of differently.
Your way of interpreting,
Anyway,
courts will interpret
Of
in
course,
its own
madam,
way, the petitioner will
of course,
interpret
of course.
way, the commission will
correct,
interpret.
correct. That
Let us see
yes,
where we
yes.
can come to.
I also
This
Lordship,
is
look
too
at it.
early
Correct.
a stage and the court is
Correct. Because,
open.
because my Lordship, just
Yes,
one
deeply
sentence.
obliged to you.
yes, madam.
Once, if I am tainted, I have to return the money. Not only three things. I have to return the money. I lose the job. For future, everything is stuck. No, just a second. So therefore, I'm trying to say tainted is not just an English word. Some fraud has to be attached to that.
Yes, that is
It's
why
not
No,
a
I have already submitted that, Mr. Dhwar. I have already submitted that.
The petitioners participated in the second SLST, 2025, conducted by the West Bengal Central School Service Commission. Stop. Their allegation is that persons who have been appointed after expiry of the panel are being permitted to participate in the recruitment process. Stop. The same is contrary to the direction passed by the Honorable Supreme Court in the matter of Boishaki Bhattacharya within bracket Chatterjee versus State of West Bengal and others. Reported in civil appeal ta diye diben. ঠিক আছে? State of West Bengal versus Boishaki. আচ্ছা. The the judgment of the Honorable Division Bench of this court in a batch of writ petitions, first of which is WPA 30649 of 2016. The court recorded the illegalities in the selection process. The court was of the opinion that appointments given to persons after expiry of the panel is illegal. Direction was passed by the court to publish the names of the candidates for public viewing. The commission has published a list containing names of candidates who have been given appointment, who were outside the panel, persons who submitted blank OMR sheets, and persons placed lower in rank. The list does not contain names of any person appointed after expiry of the panel. Stop. Next. The as an interim measure, the recruitment process is ongoing. Stop. As an interim measure, the commission is directed to produce the list of candidates given appointment after expiry of the panel. When did the panel expire?
My lord, paragraph 10, if your lordship kindly comes.
Which judgment, paragraph 10?
Of the writ petition, my lord. My lord, for 9 and 10, the panel expired on for classes 9-10 panel expired on 27.
All right, 27th November 18 and 12th of March 2019. All right. Expiry of the panel, bracket ligadinta. For classes 9 and 10, be it recorded that the panel for classes 9 and 10 expired on 12th March 2019, and the panel for classes 11 and 12 expired on 27 November 2018. The fate of the candidates whose name appears in the said list of candidates appointed after the expiry of the panel. The fate of candidature of the candidates shall abide by the result of the writ petition. Release the matter for further consideration on 9th of December.
There is also another prayer in this writ petition to publish the waiver.
9th December, can any other date, 8th or?
Already
8th. There is another prayer in this 2nd SLST to publish the waiver of all candidates. This is my specific prayer, my lord, because there are also allegations. If they are fair, the commission is fair.
In the other order that I passed on the last occasion, wasn't there a direction?
2016 process, your lordship directed for
all right.
publication. I am on this process.
Oh, this 2025.
2025.
All right.
All the waivers.
Aren't the commission publishing the OMRs?
No, for not
of
for
the
all
present
in public
candidates?
domain. It has to be public.
Lord, every candidate has got their own OMR this time.
I am not on that mind.
There are not, you are not on that, we are on other.
Every candidate has a OMR, has to be, but then why
Uh,
put it up in the public domain so that
Lord, let us, Lord, whether kindly let us give time to work to finish it by 31st December.
so
We
you
have
want to finish it and thereafter all illegalities to come up and further challenges and everything. Why don't
there
you
is
be transparent from day one? Then everything will fall in place.
that is whatever the petitioners will say. If the court reacts on that, then how we will work? How we will work?
You please work in a fair and a transparent manner.
We are working in a fair manner. Simply because they are saying that is not unfair. Our justification is there, but every point, whatever these councils will speak and court will react, then how we will work? We are ready to publish.
You already have OMRs.
I will show to your lordship OMR seats. Every OMR seats were given inspection by the Justice Bossa earlier.
The court doesn't want to see the OMR. You please put it up in the public domain so that the candidates who are really involved will see.
I have no objection that the court will not see. I have no objection. That court will see, court will not see.
I will
am
not
understand.
As our entire recruitment process is being conducted in compliance of the direction passed by the Honorable Supreme Court, the Commission ought to ensure that the process is fair and transparent from step 1. To rule out any illegality in the process, the Commission is directed to put up the OMR sheets of the candidates in the public domain so that
2025, 2020.
none has complaint against any candidate.
Of 2025,
complaint would be there. That is not that complaint would be there. Atripto Atta, that is complaint would be there. Complaint is justified or not, that's a different thing.
What you said, 9-10? All OMRs, 9-10, 11-12, all examinations. All examinations. Yes, it will come up on the 8th.
8th, yes. 8th ki baat hai?
Monday.
8th, my lord, on 8th, your lordship has been.
My lord,
That
my
time,
lord, my lord, sorry, my lord, kindly keep it on 10th, my lord. Kindly keep it.
First it was 9th, you suggested 8th.
No, no, I said
then
8.
did
I'm sorry, I did not, my lord, consult the date. Kindly keep it
It
on.
will be 10th. Date is
Yes.
fixed on 10th.
Right.
On a publication will be made.
And because of my inconvenience, that's why I said. Not for
Publication
any
will
other.
be made immediately at
It
the
will be
earliest.
done before. It will be done before 10.
All classes. Bracket লিখে দেবেন তো 9, 10, 11, 12 all.
I appear for the petition. Lordship, first straightway come to page 36.
Yes. This is also against the commission.
Yes, this is, I have some grievance against the commission. Madam, I made an application, kindly take note, application fees, SC, ST, oh, sorry.
36?
Yes. 36, kindly, the applications are all online. Now, for general.
How many candidates are here?
31, I shall pay today itself. Today itself. My lord, may I just say in crux? My lord, for SC, ST and PH, physically handicapped candidates, for applications which is exclusively online, payment has to be made 200. For general, 500.
Application fee?
Application fee. Now, we belong to SC, ST and PH. So therefore, following 200, we made an application. And admit card was also given to us. Our certificates are long before. We are SC, ST and PH. There is no dispute on that. The last date of application was, in the advertisement, it was mentioned 14th of July. There was an extension. It was made ultimately 21st of July. So once we made an application, thereafter, my lord, we thought everything in fine. We are SC, ST. We got the admit card. Now, what the commission they have done, when they, my lord, issued this list, what we find that they have treated me as the general. Kindly have a look at.
What is the fee for the general candidates?
500
rupees.
Yes.
All right. Yes.
And if I can, there are 4 pages I shall be showing. First, kindly see 36.
Yes.
36 that I was treated, because it is not that I can write it down. It's their online thing. So if I am ST, then it will come as that. So 200 as an SC. Thereafter, kindly see 72. 72, the admit card was given.
Yes.
Now, the last date, Lordship may kindly see that page 29.
VH candidate, what is VH?
Visually.
Handicap.
Yes.
All
Well,
right.
still they use that word, though we.
All right.
Yes. But, page 29, Lordship will be able to see the last date.
Last date.
Yes, I have there is reason showing for
application fee.
Yes. Page 29, Roman 3.
Yes.
Last date of receipt of the application. There is a reason why I am referring to the last date, because the rule says every eligibility that gets frozen on the last date. It's not that after. So we made within time. This 14/7 was extended, so Lordship mark it as 21/7. There is no problem. Now, thereafter, what they do, Lordships might be aware, there was our High Court delivered a judgment on OBC that certain 66 categories found to be not properly done. So matter was pending before the Honorable Supreme Court. Suddenly, what they do, they have a old website, they have a new website. All these notifications were in the old website. In the new website, they give this. No, just give me the notice. Kindly see page 131.
Yes.
This is in the old website they give at page 131. Kindly see the reference of an order of the Honorable Supreme Court which is of the OBC matter. I have taken the copy of the order, nothing to do with SC/ST. Then they mention having regard to the orders which may be passed in special leave petition order copy to review. Filed in the Honorable Supreme Court of India arising out of the judgment and order dated such and such, Honorable High Court such and such, and connected writ petitions for time being, category details are not being collected. There is no reason of not collecting category for the SC/ST at all, because it is not an issue. In any case, if you don't collect, you don't collect. You cannot suddenly put something which was not there, and will be collected in due course prior to applications being processed. Thereafter, those are not relevant. Then next page, Lordship, kindly see. Again, this notice they are giving in the old. Again, they are giving, this is to notify all concerned in such and such, SLST such and such, in view of the order dated such and such of the Honorable Supreme Court. I have the copy of the order. I read it. Nothing to do with SC/ST. And other connected matters. The online portal will be opened for collection of category details from, they give only for 5 days. What they have done is, I am an SC, some others are ST, someone is PH. We have applied as so. They have given me admit card on that basis. They have accepted the reduced reserve category fee also. Now, the surprising thing, when the result was out at one, kindly take the result at page 188, the same persons I am showing. I got 60. Now, as an SC, Lordship would be able to see SC page. Next page. Last person who has got the highest mark in SC is 63. Whereas I'm supposed to be there. There are so many 60s are there. But I am excluded. What is the reason? They have understood orally. The reason is, after the date is frozen, those persons who did not use the drop down, so they are treated all as general. This is so contrary to, there is a direct judgment of Delhi High Court. There are 3 judgments of the Honorable Supreme Court and their own rule. If Lordship kindly have the rule. Rule, take a copy. Kindly take rule 2.1. I could have understood that my application was, there was a mistake. 2.1R. This is on the frozen point. Reserve category means a category of reservation in respect of scheduled tribes, other backward classes, and physically handicapped candidates, and other categories of reservations, if any, enforced by an order of a competent authority as at the last date of receiving online application. Not after their separate website, suddenly window of 5 days. So it's like telling me that your constitutional mandate of SC/ST is dependent on a drop down being utilized subsequently for 7 days. And I come under, if Lordship look at the all of them, their marks, if they are treated on the basis.
All right, let me hear the commission.
Yes. And there are, if I can show just short judgment, direct judgment on that. Delhi High Court first. Yes. Kindly take this. First, 2025 SCC online, Delhi 6420. 15th October. Paragraph 20 was the submission, then 23 and 24. The Learned Counsel, this is a submission, so I should, it's not the courts, but court accepted. The Learned 6420. The Learned Counsel for the respondent further submits that a minor and technical error in the drop-down menu cannot override substantive eligibility and merit. Well, I need not read further. And this court ultimately had 23. The issue that arises for consideration is that whether a minor, this is a case assuming there is a mistake. In my case, I made not that 100 rupee mistake. I made correctly. And thereafter, I am waiting. And my marks are within the zone of the SC, ST and the PH. And 23, 24, the record establishes that the respondent possessed the B.Ed. Well, I just forgot only one rule. In the schedule, kindly take the rule once more, my lord. I just forgot. It's a page 9 of the rule, schedule 1. Kindly take, my lord, the nota bene third. One first para, right hand side, age limit. Well, the first is minimum 21. Thereafter, leave that last one. For consideration of application, SC, ST, OBC, PH category certificate issued by the competent authorities of only the government of West Bengal as on before the last date. So that's in sync. They are nobody to tell me whether I'm SC or ST. I have been declared by the competent authority as an SC, ST and PH, which they cannot tinker with. And I made an application accordingly. Now they cannot treat me general. There are 3 other judgments, but I did not.
On the same line.
Yes, same line.
Yes, Commissioner.
And my prayer is that now this is going on credentials. I should be allowed subject to, because I don't want everything should be stalled, but my marks are there.
Yes.
My lord, kindly come to page 132.
132. Yes, 32.
Well, this point was dealt with by your lordships in EW's matter. Still no answer.
Yes.
Kindly come first, my lord, 30th July 2025. This to notify the all current connection for class 9 and 10 in the view of the order 2787 of the Honorable Supreme Court in so and so, and other connectors. The online portal will be open for collection of category details from 5th August 2025 to 11th August 2025. He did not submit. Then, my lord, kindly see the addendum, page 133. That is 5th August 2025. In continuation to our notice issued video memo number so and so. This is to further notify that information to the all concerned all candidates, irrespective of their category, are required to mention their specific category, caste, class, EWs, PH, etc. in the respective place in their appointment form through the edit option provided in the website from 5th August 2005 to 12th August 2025. Then, my lord, kindly come to next 134. This is, my lords, regarding mentioning caste category. This is to notify that all concerned that though opportunities for updating, editing caste category have been offered to the candidates several times. A number of candidates have not yet updated their categories in their application form. Therefore, last opportunity is being given to the candidates to update this same in their application from 2nd SLST for classes 9, 10, 11, 12, 22nd September to the 26th ones. In any case, any candidate fails to update his within 26 September 2025, the category of such candidates will be treated as general. However, he did not edit this within the time limit given by him. Therefore, he has been treated as a general candidate. So far, my lord, the website is concerned. Website, my lord, we have given that the West Bengal School Service Council website. You got it. There, my lord, old SLST candidates portal. There also old website has been mentioned. That is also, if a person doesn't follow, my lord, we are helpless. We have given the 3 times chances have been given. He was not taking the chances. So far, my lord, I am not doubting about his scheduled caste. Who am I? I am nobody whether he is scheduled caste. My concern only that you must fill up the form when the addendum is given. What has happened when the initial advertisement was issued, litigations were going on. Then ultimately Supreme Court has stayed the division bench order. Then the categorization has been made. OBC, it's ABI, it's there, civil caste, civil type, etc. There. About 3 times he has been given. They have been given the chance. I don't, my lord, legal principles would be applicable in a case for a litigant who is conscious about everything, not for a sleeping litigant. Sleeping litigant. I am nobody whether he is silk or silk type, but I only wanted to know, give me the silk or certificate. You just categorize, not the verification.
I have a one-line answer. Page 132, Mr. Bandyopadhyay relied.
Anyway, Millard, Mr. Bhaur Millard, what I am subject to your lordship. He has raised a point. Let us file an affidavit. One day we will come in the month of January and we will argue the matter. Mr. Dhar was saying earlier that the one day we will come in other matters to argue. So let all that matter be finished.
Only one sentence. Mr. Bandyopadhyay has referred 132.
And Millard, addendum means your lordship is aware that there are just 1 minute. Mr. Dhar, just 1 minute. Mr. Dhar, just 1 minute. Just 1 minute. Millard, there are number of cases, judgments are there. Addendum means continuation of the original notification.
I copy one sentence. 132. Kindly look at the first sentence of 132. It refers to an order of the Honorable Supreme Court, which I have annexed at 173. This is exclusively on OBC, and OBC matter. Nothing to do with SC/ST.
The petitioners claim to be members of scheduled caste / scheduled tribe and physically handicapped category. Stop. They participated in the recruitment process for appointment of assistant teachers under SLST, second SLST, 2025. Stop. They submitted their application form in response to the advertisement published by the, notification published by the West Bengal Central School Service Commission on 30th of May 2025. Stop. The last date of filing the application along with the application fees was 14th July 2025, later extended till 21st July 2025. Stop. At the time of filling in the application form, the petitioners mentioned their caste and also paid the fees meant for SC/ST and PH, that is rupees 200. Stop. Fee for the general and OBC candidates is rupees 500. Stop. On 24th June 2025, the Commission published a notice mentioning that having regard to orders which may be passed in special leave petition, bracket open, diary number 34016 of 2025, State of West Bengal versus Amol Chandra Das and others, category details are not being collected and will be collected in due course prior to
Sorry to
the
disturb,
application
Miller, with your lordship.
process.
May I go?
Yes. Please,
Sorry
please.
to disturb you. Miller.
No, it's prior to the applications being processed. A further notice was published by the Commission on 30th July 2025, mentioning that all concerned in connection with second SLST in view of the order dated 28th July 2025, passed by the Honorable Supreme Court, in SLP within brackets C number 17422 of 2025, bracket open, State of West Bengal versus Purabi Das and others, and other connected matters, comma, the online portal will be opened for collection of category details from 5th August 25 to 11th August 25. Stop. The candidate will have to log in and choose the edit option. Stop. Then the candidate will have to select the category from the drop down menu. Menu. Stop. The candidate will also have to specify his subcategory. Stop. Yet another notice was published by the Commission on 5th August 2025, notifying that in continuation of the earlier notice dated 30th July 2025, all candidates are informed, irrespective of their category, to mention their specific category, bracket open, caste /class /EWS /PH, etc., in the respective place in their application form through the edit option provided in the website from 5th August 25 to 12th August 25. Stop. It was clarified that only candidates from OBC category were required to mention their subcategory from the drop-down box. Stop. Others, bracket open, including general candidates, bracket close, will mention their category only. Stop. Last of such notices was published on 22nd September 2025, mentioning that the candidates are provided opportunities to update /edit caste category from 22nd September 25 to 26th September 2025. Stop. It was mentioned that any candidate who fails to update the category within 26 September 2025, shall be treated as general. Paragraph. The petitioners did not avail the edit option provided by the Commission by its various notices starting from 24th June 25 till 22nd September 2025. According to the petitioners, as they mentioned their caste details at the time of filing the application form at the very initial stage within the stipulated time period, comma, there was no requirement for putting in further, not putting in, updating further caste details. Stop. It has been submitted that the petitioners paid the fees meant for SC/ST and PH candidates. Stop. According to the petitioners, their right to be treated in a particular class crystallized on the last date of filing the application. Stop. In support of such submission, the petitioners rely on the rules according to which the recruitment process is being conducted. Stop. Rule 2 within brackets small r of the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, bracket open, except work education and physical education, comma, classes 9, 10 and classes 11, 12, bracket close, rules, comma, 2025, কি দিয়ে শুরু করলাম? Mentions that reserved category means a category of reservation in respect of scheduled castes, comma, scheduled tribes, comma, other backward classes and physically handicapped candidates and other candidates and other categories of reservation, comma, if any, in force by an order of a competent authority as at the last date of receiving online applications as may be notified pursuant to advertisements to be issued. Stop. Next. It has been submitted that there was no requirement of updating their caste details as admit cards were also issued in favor of the petitioners. Where are the admit cards? Was the caste mentioned?
Yes, yes. No, they have not mentioned for anybody.
Acha. কি বললাম? আচ্ছা, এটাকে কেটে দিন। Reliance has also been placed on the judgment delivered by the Delhi High Court in the matter of Kendriya Vidyalaya copy reported in 2025 SCC Online Delhi 6420, wherein the court was answering as to whether a minor technical entry in the online form can override substantive eligibility. Next. The prayer has been made না তার আগে it has been submitted that the um, result of the written test has been declared and the petitioners scored marks which may be treated as an eligible mark for participating in the interview process had the reservation been provided to the petitioners. Stop. All the petitioners have been treated to be general category candidates. Prayer has been made to treat the petitioners as reserved category candidates in accordance with their declaration given in the application form. Stop. Next. The prayer of the petitioners has been opposed by the commission. Stop. It has been submitted that as many as 4 options were provided to all candidates to update their category details. The petitioners failed to act in accordance with the notices published by the commission. Stop. The petitioners were not diligent about their rights. Stop. The court ought not to stand in favor of indolent litigants. Stop. It has been submitted that as the petitioners did not disclose their category details accordingly, they have rightly been treated as general category candidates. Stop. Next. I have heard the submissions made on behalf of all the parties, not all, both the parties, and have perused the materials placed before this court. Admittedly, the application form filed by the petitioners within the stipulated time period disclosed their category details. Stop. The petitioners submitted the application fee in accordance with their category. Stop. The fee meant for general category candidates, generals and OBC candidates is rupees 500 and the fee for SC/ST/PH candidates is rupees 200. Stop. The notices published by the commission after expiry of the date for filing the applications required the candidate to update/edit their category details. The petitioners never intended either to update or edit the category details disclosed by them at the time of filing the application form. Stop. Had there been any change in the category of the petitioners, there would have been a necessity or a requirement to update or edit their category details. As there was no change in the category of the petitioners, they did not feel the necessity to change the same. Stop. Moreover, the petitioners paid the fees meant for for their respective reserved category. Stop. The notice of the commission that anybody who fails to update or edit their option shall be treated as general category without paying the application fee meant for general category cannot be apprehended, cannot be understood. Stop. The distinction between the fee structure was kept. No, the difference between the fee structure was kept distinctly separate only for identification. Stop. A candidate who pays 200 rupees to avail a particular category cannot be treated to be general without paying the proper application fee. Stop. Next. The rules of the rules pursuant to which the recruitment process is being conducted recognizes the category as on the last date of receiving online applications. Stop. The submission of the commission that the corrigendums, not corrigendum, slash corrigendum addendum notices were published in terms of the order passed by the Supreme Court does not help the case of the commission, particularly because of the reason that the case before the Honorable Supreme Court did not deal with the scheduled castes or the scheduled tribes or the physically handicapped category. Stop. Direction passed by the Honorable Supreme Court in a particular matter was in the case mentioned in the notices was in respect of the other backward classes category. Stop. As the petitioners did not form the part of the other backward classes category, accordingly, the direction passed in that matter cannot adversely affect the right of the petitioners. Stop. Next. The question of editing or updating category details arises only if there is a change that is to be made in the application form. As there was no requirement of any change, the category disclosed by the candidate in the application form has to be treated as final. Stop. The commission cannot suo motu treat any candidate as a general category candidate despite the candidate's disclosure of being in a particular reserved category. Stop. Moreover, the caste of a candidate gets determined at the time of his/her birth, and the same does not depend upon issuance of any certificate in his or her favor. Stop. The petitioners claim to possess their respective respective reservation certificates in the SC/ST and OBC category.
No, not OBC, PH.
As a PH category. Stop. The petitioners have to be treated in the declared category. Stop. The Honorable Delhi High Court, in the matter of Gitanjali Yadav within brackets Supra, took note of the aforesaid fact and was of the opinion that eligible and meritorious candidates cannot be this is something with regard to the faulty design of
Yes,
the
in my case, I didn't make a fault.
right
Drop down fault. So that's what
drop
I'm saying. Even in an extreme case where he made a mistake for drop down, even his eligibility was there, it was allowed.
Don't deal
My
with
case
it.
is my lordship need not.
Anyway,
Yes,
it's no requirement of dealing because
yes, need not. I understand.
the judgment of this court is
I
there.
understand.
Ram Kishore Girogia is there.
But Ram Kumar, I have brought also.
Yes, so it is.
I have brought Ram Kumar, paragraph 1560. Yes, that's
it's absolutely the same thing.
16. This is Ram Kumar.
It cannot be.
1516 para.
Charles also.
Because Lordship's language was exactly 15 and 16.
যেখানে কেন্দ্রীয় বিদ্যালয় বলেছিলাম রেফারেন্স সেখানে এটাকেও লিখে দেবেন reference has also been made to the judgment delivered by the Honorable Supreme Court in the matter of Ram Kumar Gijroya versus Delhi Subordinate Services Selection Board and another. Reported in 2016 for SCC 754. ঠিক আছে
Citation 16. From page 760.
Yes.
Just above paragraph 16.
All right, I'll just take a note. I'll dictate it later on. ঠিক আছে কোনটা কাটলেন দিল্লি হাইকোর্টটা কেটে দিন ঠিক আছে in view of the above the instant writ petition stands disposed of by directing the commission to treat the candidates in the respective categories that they disclosed in their application form. Stop. Nothing more.
Yes.
This will suffice.
But I have only one submit. I said that I shall pay the court fee by today. Most likely it would be can it be by tomorrow? Because I was told that there may be.
The leave is granted to the advocate on record of the petitioners to deposit the deficit court fees by course of tomorrow. Deficit court fees in respect of 30 candidates in course of tomorrow. ঠিক আছে
Well, possibly fourth is the last date.
See what happens. An appeal will be carried. So
yes. Now
take your time.
Yes. But deeply applied.
Yes.
I am appearing on behalf of the petitioner, my lord.
This is also commission.
Yes, my lord. The
Yes.
wrong assessment of the answer script.
All right.
My OMR sheet, page number 44.
Yes.
And the model answer key given by the SSC, that is page number 45 onwards up to page number 47.
All right.
This is quite complex. To make it easier, my lord, because of that, I just explained just page number 47. Then, my lord, I will come page number. Just turn page number 47. In the left-hand side, extreme left, that is master series. A is the booklet series. Kindly turn OMR sheet. Just a OMR sheet. There is a booklet series. Got it, my lord? In OMR sheet, column 5.
Column
That
5.
booklet series.
Booklet
So
series.
mine is the C. So mine booklet series is C. So this.
How did you get to know it is C?
My lord, kindly see booklet series 5.
Booklet serial number.
Yes, my lord. Kindly see the 5. What is, my lord? Booklet series C. What is, my lord? In OMR sheet.
OMR sheet, page.
Serial number 5. Page number.
Serial number
5.
Yes, yes, booklet series.
What is, my lord? So,
it is C.
C. Yes.
All right.
So mine is because there are 4 booklet series. A, B, C.
Yes.
So mine is C.
Right.
So, my lord, kindly turn page number 47. Just I make it easier how I calculate it. And my lord, this booklet series C means that above there is 4 column A, B, C, D, and master series is 1, 2, 3. This is the master series and up to 60. So if my series C, then kindly then second column, my question number 1, the master key is 36. For my question number 1, the
No, 1 minute. Master is the question number.
Master is the question number. Yes.
All right.
Yes.
So question 1, correct answer is C.
No, my lord.
40.
Question 1, correct answer is A. Correct answer is given in page number 46. For which series, which one? So you have to calculate it by comparing 3 pages.
All right.
So make it easier, I made a chart by the petitioner. Kindly turn page number 50. So I just page number 50.
Page number 47. What are these? 53, 42, 40, A, B, C, D. Master.
This is booklet series A, B, C, D is the booklet series.
Yes.
And this is the question number
1, 2, 3, 4.
For question number.
Yes, next.
And this is question number, and this is the master series. 36 is the master series. Kindly turn it, page number 46. In 46, question number master 36 is A. For that right answer is A. Question number 1. That is question number 1.
Question number 1, right answer is D.
C series, master 36, and answer is D. Answer is A. Sorry, my lord, answer is A.
36 A.
A. Yes.
All right.
A. So, my lord, I make it easier to make it because you have to compare each and every question. To make it easier, kindly turn page number 50.
50?
Yes, 50. 50.
50.
Yes.
All right.
So, petitioner by comparing this master series with OMR sheet with final answer key,
all right.
petitioner prepared this chart.
All right.
Up to question number 60. Suppose for question number 1, petitioner answer is A. Okay, I'll turn page number 50. Forget about the earlier page. So how I calculated to demonstrate it, I just made it. For question number 1, petitioner gave answer key A, and petitioner and SSC answer is also A. So
and this is the SSC answer in the first round?
No, final round.
This is the final one.
Round. After comparing, compared everything, I prepared it finally. So, question number 1, petitioner answer is A, and SSC answer is A. So I am entitled the marks. In this manner, my lord, suppose in question number 4, I did not get the number. That means petitioner gave D and SSC is A. By comparing this manner, my lord, I got it. Then I am entitled 54 marks.
All right.
They given 53 marks. My lord, kindly turn page, start of page number 49. Page number 49.
Yes.
OMR marks, mine was given 53 and 10 marks educational qualification. So they given 63, cut off is 64. By calculating this manner, I got 54.
All right.
If I got 54, then I will come with the zone of consideration. That's why I filed this writ petition. And in this regard, I also made a representation also, which is annexed with my writ petition, page number 52, after seeing all this, my lord. But they sit tight about the matter.
All right, but then, no, how do you say that you are entitled to 54 and not 53?
By comparing this, by 50, page number 50. Page number 50 is my calculation sheet. Page number 50 is my calculation sheet. Page number 50 by analyzing these 4 pages, page number 53.
Nobody is there on screen.
No, my lord. I'm here for the commission. Well, it kindly turns to page 44.
Yes.
But I will need to seek instructions to aid my learned friend, because at page 44, if Malad comes to answer numbers 6, 38 and 49.
6,
38,
38
and 49.
49.
Well, it appears that they have not been bubbled properly. In fact, there is no bubble. And if this has gone through the machine, if this is, it has been calculated in such a manner. So Mallet kindly allows me to come back with instructions. I shall compare it with the final answer key, and then I will submit on.
Yes, my understanding is completely right. But this is a carbon copy.
Absolutely. So that is
original.
Absolutely, my lord. Keeping that in mind, I'm submitting that. Let me compare it with the final answer key, and I shall come back.
The petitioner participated.
Don't need to file a report. I'll bring the answer key in whatever the
second
learned code. I mean,
LST, 2025 stuff. After the final answer key was published by the commission, the petitioner found that he was awarded 53 marks. Stop. According to the petitioner, he ought to be awarded 1 more mark. That is 54 marks. Stop. The OMR sheet of the petitioner is annexed to the writ petition. Stop. Learned advocate for the commission seeks time to revert with instruction. When?
Well, at any time next week, Malad.
Today is 27th.
We are 27th.
Next Thursday, I keep it?
My lord.
4th. Released on.
Just keep a note that this is to be kept on the 4th.
A report disclosing as to whether the petitioner was properly awarded 53 marks or is entitled to 1 more mark. After verifying the OMR sheet of the petitioner, shall be placed before this court on the adjourned date. Next, great. Yes, service is taken on record.
Item number 6, we appear for the petitioner.
And this is also a commission matter?
Yes. And to start with, may I say this, my lord, I had to go back to my school days for reading chemistry in these matters because
go.
Yes,
Everybody doesn't have that
but
ability.
No, I also didn't have that ability.
Yes.
But the answers keys that was being demonstrated by the commission had probably taught me something.
Yes.
The petitioners are all untainted candidates, in-service candidates. They participated in this time's SLST 2025 and they were given the preliminary answer keys. Objection was raised for 5 questions in the chemistry papers. Now, these 5 questions were objected to, and in the final result that was published, 3 questions were said to be correctly objected by the petitioners. And accordingly, 3 marks was issued. Leaving aside 2 important questions. Why I say 2 important questions? Had these 2 important questions been answered correctly by the commission, then I, who is at 1 mark short of the cutoff marks, should have got 1 mark ahead.
Yes.
My lord, I'll take your lordships to 2 questions. That is, my lord, initially, to start with, may I take your lordships to, my lord, page 104.
Now tell me one thing. Initial answer key was published. You objected.
Yes.
Out of 5, 3 were found to be proper, 2 not.
2 not.
Final answers key has been published. Now you have a problem.
Problem with 2.
Whatever.
Yes.
According to the commission, the expert body is the last word.
According
Why
to the
does
commission.
Court interfere.
According to the commission, which
Yes.
cannot be a gospel truth before this honorable court.
Now then the court has to re-evaluate.
My
Who
lord,
is going to find out?
My lord, I'll beseech your lordships to have an independent agency to be appointed for this.
Today-
Why I say this?
Today you come up for an independent agency for chemistry. Somebody will be there for history, for physics.
But the commission's role for all these years cannot be said to be a sacrosanct role
It's
that the
true.
commission has played.
But then
And 1-2 marks will make a hell lot of a difference.
everybody knows it. Matters are coming. The
Yes, my
court
lord,
is
that is
aware.
the whole difficulty.
Then
And I'll demonstrate from the appended articles that the answers that I have put in was correct. I have my clients with the books also.
the court is only interfering
Mal.
in matters where the initial answer
Mal.
appears to be proper with that of the candidate,
Yes.
but the same gets changed at the final answer stage.
Yes.
Yours is not
is- this
such
is-
of a case.
This is absolutely the other way around.
And right now you have to take it that whatever is the expert opinion is proper.
My lord, probably subject to your lordship's kind sanction, my lord, we, the candidates who were in service, who were not tainted and had suffered the wrath of this
This is
at the cost of the
nothing to
commission.
do with tainted or untainted.
I understand, my lord, at the cost of the commission, we are facing this.
What can
And
be
now
done?
the commission's role in so far as in my lord, finding the truth of what is the correct answer, your lordships in the morning was dealing with such kind of a matters where
Exactly.
answers were cryptic.
I do not know cryptic or not, but then one question may have more than one answer.
Yes, that is one such issue over here. Question 13 and 32. These are 2 questions. And I'll demonstrate from the facts of this case, my lord, that these 2 questions ought to have been marked in my favor, which they have not done. And in doing so, I am losing 1 mark, which could help me to come over the cutoff marks.
Let me see the question and what
Well-
is the basis for your submission
Yes.
that your answer is proper.
But kindly takes page 104 of your lordship's brief. But 104, the question number is 13.
13,
13, 1-3.
1, 3, yes.
Yes. My lord, may I read?
Identify the
Identify the
statement.
correct statement about the equilibrium constant and ionic strength. The answer that the petitioners has given is answer A.
All right.
That is
Whatever.
dimensionless.
This is the-
And the commission has registered their answer to be D.
D.
Now, my lord, I'll take your lordships to the articles that I have annexed to this petition. My lord, kindly takes page 105.
One
is the
minute.
book.
1 minute. The question is K is dimensionless and I has dimension. Here it says both are dimensionless. All right.
They suggest that both are dimensionless. Hence, at the outset, I said I had to
Yes.
deliver.
Where is the
Page 105, the book starts. I have the original with me.
whose book is this?
My lord, this is the book
Is
of
this book recognized by the commission?
my lord, we have this my lord, ISBN number at page 106, which suggests that this book should be recognized, my lord, at the right hand corner bottom.
Yes.
ISBN.
Where is it? ISBN, and what does that mean? What does ISBN mean?
My lord, it suggests, my lord, that the commission will recognize this book to be in their curriculum.
In
Well, as
Central
on
Standard
instruction,
book? Oh, acha. All right.
my lord, thereafter, kindly takes page 107.
All right.
The particular part that I want to emphasize.
2021 is.
My lord, kindly marks that it was the answer was suggested as dimensionless. My lord, I say, my lord, second paragraph, 3 lines from the bottom to consider the influence of all the ions on the mean activity.
Which portion? Which
Well,
portion?
second paragraph.
Oh,
The first, it starts with ionic strength. 2 lines is the paragraph.
107.
7.
Yes.
And the second paragraph starts with log.
Yes.
But I'll take your lordships to third line from the bottom.
Right.
To consider.
Huh?
To consider the influence of all the ions on the mean activity coefficient of an electrolyte Lewis, introduce the term ionic strength represented by capital I.
Sir,
or
please don't go through all this.
Well, I'll
If you
take
can
your
show me
one
line.
One line. Since
Yes.
the line begins with that, I had to, my lord, which is frequently considered. Well, ionic strength is a molar scale. Molar scale is represented as. Well, this molar scale my lord, per se says that the ionic strength can be measured. And once the particular ion can be measured, it cannot have a dimension. It ought to have a dimension. It cannot be said that it is dimensionless. There is a unit which could be measured. It per se has to have a dimension. My answer was dimension. K is dimensionless and I has dimension. I here means ions. And this book suggests that the ion, it could be measured in a scale. Hence, if it can be measured in a scale, there has to be a dimension. It cannot be in vacuum.
I am getting matters where pages of books published by the expert members who are there in the commission are annexed. Do you have anything of that sort? No, okay, is this person also a member of the expert committee or the
we are unaware that what books the expert committee is following.
No, not the books. Thing is, the details of the expert committee is there possibly.
No, it is not there.
It's not there.
It's not there. Construction.
I do not know.
And question number 32 also I can refer from the annexure that I have annexed.
32.
Well, kindly takes page 122 of your lordship's brief.
122.
Well, page 30, question 32. Well, for a reaction, the rate constant is found experimentally to decrease with increase in temperature. Identify the correct statement below. Well, the question probably suggests that which is directly proportional, whether the rate constant
let
is
us
directly
go into this. What was your answer?
But my answer was A.
All right.
The reaction does not obey Arrhenium's equation. Arrhenium's equations. The answer they had suggested was C. The reaction is a multiple step. But I can suggest, I can not suggest also, but I can very well demonstrate page 123.
It is the book of the
It is the book that is recognized, page 123. Your lordship will find, my lord, ISBN.
Same person. It's
same person.
Yes.
And there are more references which we have. This is one of such. My lord, kindly takes, my lord, page 125. First paragraph. Arrhenius empirically established the relationship between the rate constant and temperature for curve 1. Hence, type 1 curve is called Arrhenium's curve, while the other are called non-Arrhenium's curve. Huh? So the answer I had given is that the reaction does not obey Arrhenium's equation. But I say on instruction also that both these answers may be correct, but my answer cannot be struck off. And there has been situations, I'll demonstrate from those 3 answers which had been said to be correct. I can demonstrate here in Malad. Kindly takes up that they have marked one of such answers to be correct in all both occasions, both the things. Kindly takes up my lord, my answers that my learned friend Mr. Ahmed was just showing, page 99 of your lordship's brief. Is the master key. Page 100 is the preliminary answer sheet. And page 101 is the final answer sheet. But kindly takes over that page 102. Well, this 44, 102, just at the top, this 44 number question was objected to, and it was found marks to be awarded on attempt. But it is not that I am objecting in sky, and it is that I will show from your lordship's brief at page 20 at this kindly takes 27, and in that very column, page number 27, marks to all. This also I had objected to. And one more answer, 174 টাকা ফেলে বলো। 27 করলাম, 44 করলাম, আর এটা 36 না, মানে 36। Well, kindly sees the next page.
Let me hear Mr. Bandyopadhyay.
Lord, this out of 6 persons, 3 persons raised objection within time, and the 3 persons have raised objections beyond times. Therefore, 3 persons cases cannot be considered at all. And so far, this, my lord, the expert committee which has decided that has to be treated as a correct answer. Now, my lord, I just make a very short, my lord, this argument, since on number of matters it is going on judgment. Now, kindly take this judgment. This is 2021 to Supreme Court cases 309. But what he is asking for, he is asking for re-evaluation of the answers by your lordship's court.
Yes.
My lord, kindly come to paragraph 14.
Paragraph
14.
All right.
Though re-evaluation can be directed if rules permit, this court has deprecated the practice of re-evaluation and scrutiny of the questions by the courts which lack expertise in academic matters. It is not permissible for the High Court to examine the question papers and answer sets itself, particularly when the Commission has assessed the intrinsic merit of the candidates. Courts have to show deference and consideration to the recommendation of the expert committee who have the expertise to evaluate and make recommendations. Examining the scope of judicial review with regard to re-evaluation of answer sets, this court in Rambijay Singh held that the court should not re-evaluate or scrutinize the answer sets of a candidate as it has no expertise in the matters and the academic matters are best left to the academics. This court in the said judgment further held as follows. Now, this is a then not kindly they quoted, then it is further unfortunate that paragraph 32. Despite several decisions of this court, some of which have been discussed above, there is interference by the courts in result of examination. This places the examination authorities in an unenviable position and they are under scrutiny and not the candidates. Additionally, massive and sometimes prolonged examination exercise concludes with an air of uncertainty. While there is no doubt that the candidates put in tremendous effort in preparing for an examination, it must not be forgotten that even the examination authorities put in equally great efforts to successfully conduct an examination. The enormity of the task might reveal some lapses at later stage, but the court must consider the internal checks and balance put in place by the examination authorities before interfering with the efforts put up by the candidates who have successfully participated in the examination and the examination authorities. The present appeals are a classic example of the consequence of such interference. While there is no finality to the result of the examination, even after lapse of 8 years. Apart from the examination authority, even the authorities are left wondering about the certainty or otherwise of the result of the examination. Whether they are passed or not, whether their result will approved or disapproved by the court, whether they will get admission in college or university or not, and whether they will get recruited or not. This unsatisfactory situation does not work to anybody's advantage, and such a state of uncertainty results in confusion in words confounded. In view of the law laid down this court, it was not open the review of the division bench to examine the correctness of the question and the answer key to come to a conclusion different from that of the expert committee as judgment so says judgment Miller, this is the proposition of law. Therefore, Miller, the scope of what my learned friend is submitting, that I appreciate his knowledge in respect of chemistry. I appreciate, and he has said so. But I am also a chemistry student, but I don't have so much knowledge. But since legal brain has been for 45 years, I am in the legal field. My naturally legal knowledge has been developed. Chemistry knowledge has gone. Now,
Yes.
therefore, it is a principle.
1 minute. Tell me
And,
one
and
thing.
rules, Miller, kindly see the rules once. Rules, Miller, page 47, kindly come.
Yes, rules I'm aware.
Mal-
Tell me one thing.
Yes.
Six petitioners are there.
Mal.
Everybody objected to the same question?
No, my lord. Same questions, set of questions were objected, as my learned senior friend is correct. I have just checked up.
Yes.
That first three, the set of questions may be different, but the questions are same. A, B, C, the C, D categories. Set of questions may be different. I have the categories, I have the question. But the series are different. But the questions are same.
So everybody
And
objected to the same question, and is it within time
No,
or outside time?
first, my learned senior friend is correct when he's saying that first three candidates have filed their objection within time.
Yes.
And the last three candidates have not filed their objection within time.
Then what is the use? One who has not filed within time, why will their objection be considered at all?
They have, after the instruction I say, after the answers, final answer key were published, they have filed a written objection.
There is hardly any scope. Then nothing doing. Please come.
My lord, with regard to my lord, first three candidates, my lord, I'll last three candidates, I'll place, my lord, say that, my lord, kindly
The petitioners
have
participated
them
in the
named.
second SLST 2025 conducted by the West Bengal Central School Service Commission. Step. The result of the written examination has been published. Stop. The petitioners secured 1 mark less than the cutoff mark. Everybody.
My lord, I'll take your lordship's, my lord, page 87 of your lordship's brief.
Say everybody.
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 Three.
ঠিক আছে next হচ্ছে it has been submitted that objections were raised by the petitioners with regard to the answer in respect of 5 questions. Stop. At the time of publication of the final result, 3 of the objections raised by the petitioners were found to be proper, but the rest 2 were not. Stop. According to the petitioners, the other 2 objections are based on the study material which they have annexed with the writ petition. Stop. Paragraph. It has been submitted that the final answer key may not be proper, as the study material suggests that the answers provided by the petitioners are also correct. Stop. Instance has been shown that the commission awarded marks to candidates who attempted questions. Stop. Marks have also been awarded to all candidates in respect of certain questions. Stop. It is submitted that had one more mark been awarded to the petitioner by treating the objection filed by the petitioners as correct, comma, then the petitioners will reach the cutoff mark and may also get 1 mark more than the cutoff. Stop. Prayer has been made to appoint an expert to assess as to whether the objection raised by the petitioners are proper or not. Stop. Aforesaid submission of the petitioners is opposed by the commission. Stop. It has been submitted that as per the recruitment rules, comma, the final answer key prepared by the expert is to be treated as binding, treated as final and binding. Stop. There is no scope for re-evaluation of the answers. In support of such submission, reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of Vikesh Kumar Gupta and another, reported in 2021 2 SCC 309, wherein the court deprecated the practice of the court. Wherein the Honorable Supreme Court deprecated the practice of the court to interfere with the recommendations of the expert committee. Stop. After hearing the submissions paragraph made on behalf of both the parties, it appears that out of the 6 petitioners, comma, 3 of them did not raise the objection within the stipulated time period fixed by the commission. Stop. However, the same questions have been objected to by the other petitioners. Stop. The objections raised by the candidates were considered by the expert body and a final answer key has been published. Stop. All the appearing candidates have been marked and their and the result has been published. Stop. There may be candidates who are not satisfied with the evaluation by the expert committee and they may have study materials in support of their objection. Stop. The candidates at the time of participation in the recruitment process were aware that the result declared by the expert committee is to be treated as binding and as final and binding. Stop. If the prayer of the petitioners is allowed for re-evaluation, then the same will be contrary to the rules published by the commission. Stop. The unsuccessful candidates who may have objections in respect of many or even one question, will rush to the court seeking re-evaluation. Stop. Such practice has not been appreciated by the courts. Stop. The court is not an expert body. The court is also not inclined to appoint any other expert to re-evaluate the Answer. Stop. The same is particularly to reach at a finality of a recruitment process, or else such objections will continue to be pouring in. Stop. Next. In view of the above, the court is not inclined to interfere in the instant matter. Stop. The writ petition fails and is hereby dismissed.
My lord, before your lordship's part, my lord, with regard to
And the deficit court.
well, with regard to the judgments that my learned senior friend has cited, my lord, I was to, my lord, make only one line submission. But may it be recorded, my lord, with this facts of that judgment may not be may not be equated with the present situation, because the commission's role for the last 1 year or so has been deprecated by the court. It is not our role that could be deprecated in this manner. My lord, kindly takes note of this submission, my lord.
Take down one sentence. Learned advocate for the petitioner submits that the facts and circumstances of OITA within brackets supra does not match with the facts and circumstances of the instant case. Stop. The role of the commission in the instant case has been frowned upon by the courts from time to time. Yes, next. Imamla. Pension.
The petition. Both the petitioners in this case, my lord, in the same situation, and they are the victim of the situation, because at the time of publication of the list, untainted first untainted tainted list of 952 candidates, their name have been appeared. Immediately after publication of the list, they filed the writ petition, moved the writ petition. After the matter has been referred to the division bench, and that is why it was pending for a long period of time. After that, the same has been went to the
What
Supreme
is the matter about? Please
Matter
say.
is- The allegation is that my number has been mismatched with the OMR
Which recruitment?
2016 selection process.
So that has been set at naught. What remains
No,
at the writ?
The petitioner claimed that my name has been appeared wrongfully in the tainted list. And kindly come to can 2 of the first assigned matter. We, as per the direction and wishes by the learned coordinate bench, we moved the SLP before the Supreme Court, wherein it has been
1 minute. I see 23rd March. This was heard in part by Justice Biswajit Basu.
Yes.
Thereafter, has it been released?
Yes, ma'am. It has been released, and then it has been assigned to Justice Parthasarathi Sen.
And then also from there, it
Then
is
also,
over here.
because after
The challenge is that your name has been wrongly incorporated in the list of
Yes,
tainted candidates. This is the challenge in the writ
Yes.
petition. But the entire selection process is of the 2016 process, which has been set at naught by the Supreme
Yes.
Court.
Yes, my lord. And I am suffering because could not appeared in the next selection process. And
Obviously.
subsequently,
Now the selection process is also over. So what remains in the writ?
no, my lord, due to that, kindly come to my name is appeared in the newly published tainted list also.
Yes.
But I am not at all tainted, my lord. Kindly,
Assuming your name goes out, assuming the recruitment process is over, what remains?
my lord, kindly. I also paid for a reinstatement in my earlier service.
That cannot be done. The selection process is gone.
Kindly come to page number 26, my lord, once. The final order term.
Is it written?
Can 2, my lord.
Can 2?
Yes, my lord. We moved before the Supreme Court.
Can 2 টা আছে কোনটার ভেতরে? এইটার না ওটার কোনটা? Sonali Das's matter. Yes, can 2?
We moved SLP before the Supreme Court.
Yes.
Wherein the commission also published one affidavit. Filed one affidavit wherein point number 3H kindly come to. They accepted the fact, despite having their knowledge, I am suffering.
I did not get it.
Kindly come to page number 15 once. The affidavit filed by the commission before the.
Is it in can 2?
Yes, my lord.
Which page?
15.
15?
Yes, my lord.
The handwritten number, or there is a printed number? Which page
Handwritten
number? Handwritten number 15. Yes.
Point number H, my lord.
Yes.
As per the commission database, the petitioner server mark is 42. However, the OMR marks as per CBI and corroborated by SSC through a fresh evaluation of the recovered OMR images is 41. Likewise, the aggregate marks of the academic score and marks obtained by the petitioner as per the commission's database is 77, and as per CBI's list is 76. As per the commission marks obtained by the petitioner in the personality test 9.5, this is not necessary. Kindly come at the middle portion. So even as per the marks in the CBI list, the petitioner would have been called for personality test from the general female category. So far as the waiting list is concerned, the last recommended candidates from the general female category, Anamika Mondol, who was not found to be tainted, scored 85 marks. That is less than the petitioner and was in waiting list at rank 2. She got recommended in phase 2 of the counseling. Thus, the petitioner would notionally have been between waiting list rank 1. And I am suffering till date. My name is in the tainted list because of the pendency.
Yes. So what happened before the Supreme Court? What order was passed? This is the affidavit of the commission. What did the Supreme Court say?
Page number 26, my lord.
Yes.
The middle portion. However, we find that the writ petition in question was filed long before the adjudication of the matter by the division bench of the High Court, which came to be confirmed by this court in the aforestated batch of cases. The grievance of the appellant that she was not liable to be treated as a tainted candidate was not adjudicated either by the division bench of the High Court or by this court. The said issue therefore remained open for adjudication by the High Court in the read petition filed by the appellant.
All right, let me hear the commission once. The issue has been kept open by the Supreme Court to be decided as to whether her name was rightly
Yes, now
incorporated.
just two aspects. Even after deducting 1 mark, the petitioner is still in the zone of consideration. This is the case. But that does not change the fact that the mark was enhanced. All candidates whose marks were enhanced, they have been removed. There are candidates even after 6 marks, 7 marks being reduced, but still in the zone of consideration. Their rank positions might have changed. Their options might have been reduced, but they were still.
But then your case is that extra marks were allotted to the petitioner.
So it is an accepted situation that the OMR which was retrieved by the CBI, they were given to us in a mirror image form, which we rechecked and found that our finding and the CBI finding was the same.
Maybe 1 or 2 marks here and there, but the finding is same that
1 mark
extra marks were awarded.
Yes, 1 mark extra. In this candidate's case, 1 mark was increased.
All right.
This is one aspect. The other aspect is after this was filed in 2023, this writ petition. After that, selection process got set aside. Fresh tainted list got published. Again, her name is in the fresh list. And then the selection
Is
process.
there any difference between the earlier list of tainted candidates and the present one?
Yes.
Anybody who was there in the earlier list, not there in this list is.
Yes, possibly that is the case. That is why the Supreme Court has those after expiry of panel, those matters are now before the court.
All right. No, they are the new ones added. But anybody who was there in the first list, not there in the second, is there anybody like this?
I'll have to take a specific instruction. So in any event, now relying upon the previous tainted list and asking for release like being allowed to join my school, etc. These are now all
those prayers cannot remain. But his submission is that as her name is there in the list, she cannot participate in further recruitment processes.
The due list was published, that too pursuant to orders of court.
Yes, yes.
Then that list should have been challenged by the petitioner in a fresh writ petition. This is what I'm trying to say. These are the two angles.
Whichever way you look,
yes.
Even if it is challenged, if you say and your record says that extra marks were awarded to the candidate, then she is squarely within the list of tainted candidates.
Yes, yes,
Then
that is there. That is there.
There is no matter of extra marks, my lord.
you may say so.
My lord,
No, none of the tainted candidates will come and say, yes, I am rightly put in that list.
my lord, I can prove it.
No question of proving. The authority says so that your name was, you have been awarded extra marks. Please come. The
My lord,
petitioner,
just interrupt. We are not exactly saying that extra marks were awarded. The marks which were recorded in our server, if we look at the first sentence of paragraph H.
Yes.
Is 42. But the marks as per the OMR sheet is 41.
That means 1 extra
So
mark.
that inference is drawn that the mark was enhanced for the candidate.
My lord, as per the answer key published by the commission at that point of time, my number was
Petitioner
same.
participated in the first SLST, 2016,
1 mark.
conducted by the commission. Stop. In accordance with the direction passed by the Honorable Supreme Court, comma, a list of tainted candidates has been published by the commission. Stop. The name of the petitioner appears in the said list. Stop. The petitioner is aggrieved by the same. Stop. Specific submission is that the petitioner cannot be treated as a tainted candidate. Stop. In support of such submission, reliance has been placed on paragraph 3 within brackets small h of the affidavit filed by the Commission before the Honorable Supreme Court, which is annexed to Can 2/2025 in WPA 4155 of 2023. Stop. It has been submitted that the Commission has disclosed that as per its database, the petitioner's server marks is 42. Stop. However, the OMR marks as per the CBI corroborated by the Commission is 41. Stop. The same implies that one extra mark was awarded to the petitioner. Stop. Next. According to the petitioner, she was not responsible for the one extra mark that was reflected in the OMR. Stop. Now, in the Commission's database. Stop. Paragraph. Fact remains that the Commission was compelled to publish the list of tainted candidates, which has been done after obtaining detailed inputs from the CBI. Stop. The criminal proceeding is pending consideration. Stop. At this stage, passing any order observing that the name of the petitioner was wrongly included in the list of tainted candidates will be highly improper and prejudging the issue. Stop. Next. In view of the above, the prayer of the petitioner for removing her name from the list of tainted candidates cannot be allowed. Stop. The writ petition and all other connected applications filed by the petitioner stands dismissed.
My lord, 1 second, can I take your lordship? I'm kindly just allow the video, please. 1 second, my lord. In the morning, the matter where your item 3, your lordships have directed us to publish the OMR sheets, full OMR sheets. That means 5 lakhs candidates are there. Well, full OMR sheets, that website will crash. Will your lordships kindly just, those who are successful, can we publish that?
The unsuccessful ones should also be published because they need to know as to why they have been unsuccessful and whether the others were rightly being treated as successful ones. You take your time. It will not crash because you do it in stages. Publish the successful ones and then come up with the unsuccessful ones. Do it in stages.
One stage by stage.
Yes.
That your lordships
Stage you do it.
within not certain. All right. First, we are publishing the
All right.
successful candidates.
All right. All right.
One submission can be recorded.
What?
The publication of the answer key on the basis of which the CBI is alleging that I am tainted or what, or my number has been enhanced. That particular answer keys never have been published by the
that is a different portion. Come up with a
on the basis of
we'll see.
on the basis of my lord, there are two answer keys, my lord.
All right. What is this matter? Sanjukta Shashmal?
Same, my lord.
Same?
Same, my lord.
What the number will tell in is will differ.
My lord, in
32 and 33.
My lord, in this case,
উপরে একটা জায়গাতে actually বলেছিলাম দুটো নম্বর বলেছিলাম কত নম্বর দিয়েছি
My lord, kindly come to page number 128 1 in this matter.
41 and 42 বেড়ে 42 41 থাকবে। one extra bar here it is 30
My lord, 33 in the server, but the OMR is 32.
32 হবে
My lord, kindly
extra mark.
come once page number 128. What is the submission made by Mr. Patro on the
128
yes
of can
of can 1
can 1 128 yes yes please
কোথায় ছিল?
what do you want to show from 128
Ms. Supriya Dubey, learned counsel for the commission, submits that she has received instruction from her client which says that in the list published in the website of the commission on December 22, 2022, through the subject score of the petitioner has been shown as 33, but on new evaluation, such score is reduced to 32. Matlab, my lord, two evaluation has been made. My point is that, my lord, there are two answer keys which
Same
has
order.
not been passed.
same order will go down
I will read by Mr. Mujumdar.
all right his name will be recorded it will be can 1 can 1 also your affidavit or is the annexed
No, possibly.
no
আচ্ছা affidavit কিছু?
is the affidavit of the commission annexed in
No,
can 1
no, no.
No,
There was no.
there is no affidavit, my lord.
তাহলে
This
ওই
is a submission
affidavit পোর্শনটা
by
হবে
the-
না শুধু সাবমিশন
But I have the instruction, but the affidavit was never directed.
ঠিক আছে ডিসমিসড আচ্ছা একটা আপগ্রেডেড মোশন আছে ডাকুন তো
পেতে ভালো। ঘরে কি হলো দেখো?
yes
That this relates to
interest
on account of provident fund, which has been illegally withheld. Matter went up to the Supreme Court. Then, my lord, kindly have a look. Other repeat.
who is your other side
You are here.
who was there
Sanghamitra Nandi.
then I'll take it up in her presence not ex parte order
At two, my lord.
no not today it will be there in the list not so very urgent
That's true.
Next matter is
next matter means
10.
no I'm not calling 10 this the combined list matters are there call 220 who is your other side
220.
yes please what is your prayer
Patron, my lord, deducted from the authorized date.
But Lordship, as per the instruction, we are objecting to the overdrawn. It was to Madam Clerk.
দেখি
Item 220.
না না
220. Item 220.
ওই কাগজটা দেখি কি দিল
Lordship kindly comes to the second paragraph, Lordship. The overdrawn has been arisen.
died in harness overdrawn amount cannot be refunded please come
I'm grateful, Lordship.
the husband of the petitioner
With item 220.
served as an approved headmaster of a school. Stop. He died in harness on 28th February 2021. Stop. The pension papers of the employee was prepared by the office and it was employer করে দিন by the employer and it was found that certain amount was withdrawn by the employee on account of wrong fixation of his pay. Withdrawn বললাম তো ওটা overdrawn করুন. Stop paragraph. The widow of the employee has approached this court for refund of the alleged amount which has been found to be overdrawn. Stop. The petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of State of Punjab and others versus Rafiq Masi. এখানে পেয়ে যাবেন. In support of the submission that the refund could not have been adjusted from the pensionary dues. Stop. Paragraph. I am of the opinion that the ratio of the law laid down in the matter of Rafiq Masi within bracket Supra will not be applicable in the facts and circumstances of the instant case, in view of the fact that the employee still had time left in his service career, within which the employer would have got a chance to rectify the error in making excess payment, and the money could have been adjusted during the service tenure of the employee. Stop. As the employee died in harness, the employer was not in a position to take steps for correcting any error in the pay fixation. Stop. Next, in view of the above, the prayer of the petitioner for refund of the alleged overdrawal amount cannot be allowed. Stop. The writ petition fails and is hereby dismissed. The instruction forwarded by the District Inspector of Schools, Secondary Education, signed on 19th of November 2025, we return with the records.
I'm grateful, Lord.
Service is also there. 226.
Time for the school authority.
Petitioner is not here.
I am a petitioner.
Oh, bolun.
I am for the respondent.
All right.
He is the miscellaneous matter. He is-
Matter, my lord. Petitioner has returned from service in the year 2013, my lord. But in the pension payment order, my lord, it has been found that private respondent number, my lord, respondent has name has been included in the pension payment order, with whom, my lord, the petitioner's marriage was solemnized, and subsequently it has been divorced, my lord. Kindly come to page.
Who are you?
I am for the person, wife. My name has been
Private
recorded.
respondent?
Yes, my name has been
Wakalatnama
recorded.
filed?
My lord,
Wakalatnama filed?
Yes, my lord. Earlier I have filed. my lord, okay.
Earlier, please check. Yes.
তোমারটা ফাইল করা হয়নি।
Show me the divorce.
Kindly come to page, my lord, 24, my lord. Relevant portion, my lord.
If your lordship kindly have a look, 48 DI has taken reason in favor of the petition
Yes, my lord.
for induction of the name
No.
of the
Directing the school authority to
Wait.
take steps.
Page 48 DI
Yes.
requested the school authority to take follow-up steps because one of incorporation in the service is required to be done by the school.
All right.
But that order has not been challenged. That is binding upon the private respondent also.
My lord, and my lord, last,
Everything has been considered.
and
Who is your wife now?
my lord, Mongola Das, one Mongola Das, my
The
lord.
registered marriage took place between Shri Mongola Das Unish as per order dated his lordship to direct the husband to make proper application. And school is afforded to receive such application. Yes.
I am for the school authority, my lord. My lord, I have repeated request to the petitioner to produce the original certified copy of the
Judgment.
decree, my lord.
That has not been produced.
No, my lord, several occasions, my lord, I have requested.
He failed.
Where is it? Certified copy of the decree.
87, my lord, the marriage
Certificate
dissolved.
Copy my lord, has been, my lord,
No.
annexed in the.
Where is it?
That is the annex, my lord,
Xerox copy.
school authority
Please
directly.
wait.
It is Xerox.
Where is it?
It is Xerox, my lord.
Page.
Page 23, my lord. Started from page 20, my lord. 19. Page 19, my lord.
Page 19.
Yes.
1987 order.
Yes.
87. Retired 2013. My name has
The
been recorded in the nominee Malad as 2013.
Because she is getting pension, my
Wait.
maintenance, my lord.
That
How
the
she can this, my lord.
the marriage between them should be dissolved and the suit be decreed and the marriage between the is decree of divorce. Why don't you obtain a certified copy and hand it over to the school?
Original.
It has been handed to my lord.
You must be having originals.
Yes, my lord. I have to, my lord.
Take an original, give it to the school. The school will act.
My lord.
What, my lord?
My lord, kindly fixing it, my lord, on next week, my lord. I shall produce the original.
Before your lordship.
I think, my lord, it required to be deposited to the school authority for incorporation. Matter will be resolved because this order has not been
School
challenged.
several occasions requested him to produce the original certified copy.
He failed. আমি তো হিয়ারিং এ ডেকেছিল মেইনটেন্যান্সের সঙ্গে এর কি সম্পর্ক 13 সালে তুমি রিটায়ার করে আমার নাম ঢুকিয়ে এখন বলছো চেঞ্জ কর
Please come. The petitioner is a retired employee of a school staff. He is aggrieved as the name of his wife is not correctly reflected in his pension papers. Stop.
No, not correctly. My name has been recorded. He has changed. He wants to change.
রেকর্ড করছেন জোসেফ শোনো
No, my lord, ও change চাইছে
ওর সাবমিশনটা রেকর্ড করছে
The petitioner's marriage with the private respondent,
342.
Srimati Aruti Maiti,
On 24th
within bracket
February
Das,
77.
stood annulled, dissolved, likhun, dissolved by the learned district judge at Alipur
কত নম্বরে শুনে তোমার
on 9th January 1987 in match suit number 335 of 1986.
দেখে নাও প্রেসিডেন্ট
The petitioner thereafter married one Mongola Das on 3rd March 2019. Stop. The petitioner prays for incorporating the name of his present wife, Srimati Mongola Das, in his official records. Stop. The District Inspector of Schools within bracket SE South 24 Paganas by a communication dated, not communication, order dated 15th January 2024 has mention that the head of the institution shall take necessary steps for change in the nominee. Stuff. Learned advocate representing the school submits upon instruction that despite repeated requests, the petitioner did not produce the original decree passed in the matrimonial suit. Stuff. In the absence of the original decree, the school is not in a position to proceed with the prayer of the petitioner for changing the name of the nominee. Stop. Next. It appears from the submission made on behalf of the parties that the erstwhile wife of the petitioner is receiving maintenance in terms of the order passed by the competent court. Stop. Next. In view of the above, the petitioner is directed to produce the original decree before the school authority. Stop. On receiving the original decree, the school shall take necessary steps for changing the name of the nominee in the official records of the petitioner. Stop. Hearing of the writ petition stands adjourned till 19th January 2026.
25th January, my lord, after 23rd, my lord, actually, after 23rd.
27th of January.
27th.
For recording further updates.
My lord, affidavit of
Service is taken on record.
And as per the Honorable Justice Sogat Bhattacharya's orders, my lord, made party, my lord, and sub.
Yes, yes, the school is appearing.
Yes.
Eta koto number holo? Who's Vakalatnama?
Managing committee of the school.
Where is your Vakalatnama? Why are you making incorrect submission in court without checking your records? What? What excuse? Where is it? You have? And a line in the leave granted to the learned advocate representing the private respondent to file the Vakalatnama in the department.
And the school, my
My
lord.
lord, I will also file, my lord. With me, my lord, I will also file, my lord.
In course of the day.
In course of the day.
No, madam, fine.
You have it with you.
My clerk has read the code for personal ground today, so by Monday.
আচ্ছা সোমবার হচ্ছে 1st December.
December.
By 1st of December.
My lord, positive.
এটা কত আইটেম? 349? Yes, what is it?
Here is the petitioner is the retired teacher.
Petitioner
is the retired teacher. Petitioner first wife died in the year 2010. Thereafter, petitioner retired. 28 February 2018, and petitioner got second married lordship 11 December 2019. And petitioner applied for the change of the name of the nominee lordship.
Yes.
And also petitioner has not been paid ROPA 2019 benefit lordship.
The two are different. You cannot mix up all cause of action.
After correcting the name of the nominee, direct to the
No.
to issue revised pension.
Correcting the name of the nominee has got nothing to do with your ROPA benefit. Where is your representation for correcting the name of the nominee?
Yes, lordship.
Who are you representing?
Page 19.
All right.
Page 19.
Page 19.
Page 22, my lord.
Page 19.
School forward the paper, lordship.
School forwarded. The school has to correct the nominee. The DI will not be in a position to do it.
For which lordship school send the paper after correcting.
My lord, it is a second marriage.
The pending before
And the first
and the
is
first
subsisting.
No.
No, died in
The first wife died. The petitioner
Married, remarried, and so next one.
Married after the date of retirement.
So here is the circular, Lordship.
So what can be done? You can restrict somebody from getting married.
My lord, in regarding his prayer for family pension regarding his second wife, it can't be.
Why
But,
not?
my lord, that according to the memo number 136.
Show me.
ED,
So here is the memo.
136?
No, Lordship.
136
It's supporting
B,
my
50.
client, Lordship. So date 28th March 2006. Ma'am.
20th March 2006.
Clarification about the definition of family pensioner, the inclusion of post-retired spouse and their children in the definition of family.
No. For you, it is not the children. It is your wife.
Yes, Lordship.
Right. But then after retirement, if
My lord, after retirement, if there is a adoption or
adoption,
my lord, adoption or
The
second marriage
remarriage.
after the date of retirement, my lord, the second wife is not entitled to get the family pension.
show me.
My lord, I forget to bring the notification, my lord. That
So
is
you rely upon a
my
notification
lord,
without bringing it.
136 EDN B 15/5/1985. The definition
Show
of
me,
family.
please.
Wait, my lord. Marking ko-
Come ready. Next day I'll take it.
My lord, 1 minute.
350.
Time for the petitioner, Lordship. Where is the Lordship, family pension of unmarried daughter, Lordship?
Where is your prayer?
Here, Lordship, page 37 started from
37 is for issuance of income certificate. This is not for family pension.
29.
29.
Yes, Lordship. Started 29.
Please come. What is your submission?
My lord,
Petitioner prays for grant of yes.
my lord,
Family pension in respect of
prays for,
unmarried daughter.
pension and along with the interest, my lord, but delayed to petition. My lord, kindly,
Who was the teacher?
Father.
father.
The father of the petitioner was the teacher who
Retired. Father retired 31st of January 1994.
retired on 31st January 1994 and received pension thereafter. Stop. What about the wife, widow?
Wife 5th July 21 died.
The widow of the the mother of the petitioner expired on 5th July 2021.
Yes,
Stop. The petitioner claims to be an unmarried daughter and seeks family pension. Stop. The prayer of the petitioner is pending consideration before the District Inspector of Schools, Secondary Education, Purva Mendipur. Stop. The court. You've got the special bench judgment with you?
No.
The court in the matter of
As per
blank.
circular, Lordship, 95 AC 13/4/2010 petition is entitled because special bench regarding Lordship pre-81.
Pre-81.
Yes, Lordship.
And
pre-81.
আচ্ছা কি বলে তাহলে এটা বাদ দিয়ে দিন এটা লিখুন the petitioner's application seeking family pension is pending consideration বললাম তো without entering into the merit of the same the instant writ petition stands disposed of directing the DI to consider the same in accordance with law at the earliest. Stop. If but positively within a period of 12 weeks from the date of communication of this order. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken.
My lord.
368?
My lord, may I secure it?
No, next day. 368?
368, I am for the petition.
What is it?
Say again, I will review service. I am for the petition, Lordship.
Who is your other side?
I have served, Lordship, but
Then I'll not take today.
yes, Lordship.
373,
23 or-
state is there?
No, Lordship.
Then next day. 510, petitioner, what is the matter? You, where is your other side? Not here. Then next day. 512, 3 also. আজকে 3:30 আছে
Lord, kindly excuse me. Kindly excuse me to mention 153, item number 153 under that, I think contempt application. My lord, this in spite of my lord's direction, my lord, the construction, unauthorized construction is going on. My lord, kindly take, my lord, if your lordship kindly so pleases to upgrade this matter, my lord, the construction will be completed by this time.
Cannot upgrade. So many matters are there. Yes, call the list.
Lord, I am for the petitioner, my lord. My lord,
The contemners, my lord.
my lord, kindly see the last order, my lord. They are, suppose they have stated, my lord, on the last occasion, that is on 11/9/2025. In the second para, my lord has mentioned, alleged contemptor submits that the process for complying the court's order has already been initiated and the same will take some time to conclude. And today the matter is fixed, my lord, and fourth para kindly be seen. An affidavit of compliance shall be filed by the contender on the adjourned date. No compliance has been filed, no steps has been taken, my lord. No notice was served, my lord.
My lord, I appear on behalf of the contemners, my lord. Even I have asked the Patwari to be present before this honorable court, my lord. On instruction, I am submitting, my lord. They have asked for the map of that particular place, my lord, from the land acquisition, collector land acquisition. My lord, they have not yet received the map, my lord. Until and unless the map, as per the map, they can identify on which portion the land has been acquired and the balance portion which has not been acquired and which has to be demarcated in equal shares to the the petitioners, my lord. So, my lord, due to the lack of that map, my lord, they could not proceed with the case, my lord.
It is not the problem of the petitioner, my lord. Kindly see the order was passed on 13/12/2024. Now again the going to finish 1 year, my lord. There was a direction to complete within 4 months. 4 months has lapsed long back. Thereafter, on the last specific order was there, they have said the process is on. So that's why, my lord, my lord has fixed the date today. Still, they have not done anything, my lord. It's, my lord, personal appearance is required, my lord. Tehsildar's personal appearance is required. Otherwise, he will not comply the order of this honorable court, my lord.
But because the lack of the map, my lord, which is very much required.
It's not with me, my lord. It's not with me.
Please come. It appears that the time period to comply the order dated 13th December 2024 expired long back. Stop. The same has not been complied till date. Stop. The explanation provided by the contemptor for not complying the court's order, as the map of the place has not been handed over by the land acquisition department, cannot be taken to be a valid ground for not complying the court's order. Step next. In view of the above, let contempt rule be issued against the contemptor, returnable on 22nd of January 2026. Stop. The contemptor shall remain virtually present along with an affidavit of compliance.
Highly obliged, my lord.
Obliged. My lord, I appear on behalf of the contemners, my lord, and we
My lord,
whether my lord has received.
My lord, in item number 3, I am appearing for the applicant, my lord. This day morning itself, they had given me the affidavit of compliance, my lord, but it is not being complied. I intend to file my exception, my lord, against the said affidavit of compliance, my lord.
Passed by my lord, that we have to pass a speaking order, my lord, and we have passed a speaking order, my lord. I have annexed along with my compliance report, my lord.
My lord, there are two queries, my lord. One is that page number 32 of my application, my lord, wherein the order has been passed. Paragraph number 12, it has been specifically mentioned by this honorable court that the aforesaid response shall take note of the allegation of discrimination put forth by the petitioner at the time of consideration of representation. It was never considered. Even in the order submitted by them, they have not reflected the said paragraph in their order also, my lord. And second thing, they are in their affidavit and everything, they are stating that they have given me an opportunity of hearing. They have intimated me regarding certain document to submit the same, but no such intimation was ever given to me. And even in their affidavit in compliance also, there is no such document stating that they have given me an intimation to submit the document, my lord. For that same reason, I intend to file the exception against the said compliance report, my lord.
Was any opportunity of hearing given to the petitioner?
No.
My lord, kindly come to the second page of the speaking order, my lord. Para
Yes.
1, 2, 3. Third para, my lord.
Yes.
And whereas the details about the required documents to all the DRMs were intimated individually, and this directorate was collecting the above said documents for almost 1 month for further extension and to fill up the details in Google web portal of DRM with daily rated Mazdoor monitoring system in the stipulated time as prescribed by the Personal Department of Indian Administration. In the case of Srimati T. Sharda Kumari, attached to PA to the Director of RD PRIs ULBS, the concern was also informed to submit the documents in time. But she failed to submit the requisite documents to this directorate before the Google web portal of DRM and was freezed by administration in February 2023.
For that, my lord, for that reason only, my lord, they were given a direction to file an affidavit that they have intimated me, but no such document they have filed. Only in the speaking order, they are telling time and again that they had intimated me, but there is no document pertaining to the same.
1 minute. Is the letter directing the petitioner to produce documents annexed in the compliance?
No, my lord.
It has not been annexed, my lord.
Did you check up as to whether actually a communicating letter upon the petitioner was served directing her to come and produce documents, to submit documents or anything of that sort?
No, my lord. It's all her on representation that was uploaded, my lord, and she was asked to
Where is this asking?
my lord.
That she was asked, what is there to prove that she was asked? Because the petitioner is refuting your submission.
My lord.
My lord, I shall produce, because if my lord sees the second para, my lord. No, my lord. Earlier it was asked to produce that. Before that.
Some document that you requested the petitioner to produce the documents. Please come. Affidavit of compliance filed by the contemptor is perused. Stop. It appears therefrom that a speaking order has been passed, allegedly in compliance of the direction passed by the court. Stop. It appears therefrom that the petitioner was informed to submit certain documents. Stop. There is nothing on record to suggest that such information was actually communicated to the petitioner. Stop. Learned advocate for the petitioner categorically denies receiving any communication with request for submission of documents. Stop. The contemptor is directed to file a supplementary affidavit disclosing documents to show that the petitioner was intimated for submission of documents, which she failed to do. Stop. Let such supplementary be prepared and circulated by 18th of December. Release the matter on 22nd of January 2026.
Obliged, my lord.
My lord, deeply obliged, my lord.
Item number 7, 190 days. My lord, I appear for the petition. Contempt, my lord. My lord, kindly see your lord, the last section, my lord. 3 months arrear pension has been released on 17th November 2025, my lord. Petition, the municipality is in under fund crisis, my lord. It is not possible, my lord, to release entire arrears pension at a time, my lord. But they are trying to, my lord, regularize the pension. So far as the my lord's order is concerned, my lord, that has already been complied with by releasing the entire gratuity along with, my lord, interest, my lord.
Please come.
Interest, my lord. So, my lord, some time be given to the
last order.
It has been brought to the notice of the court that out of 15 months pension
No payment has been made after the order.
due and payable to the petitioner, 3 months you have received.
That was prior to this order.
No, my lord. 17th November 2025, my lord.
3 months
My lord.
pension
My lord.
has been released.
Instruction and submitting, my lord.
3 months pension has been released on 17th November 2025. Next. It has been submitted that due to acute fund crunch, the entire dues cannot be paid in one go. Stop. Acha. Hearing of the contempt application stands adjourned till 29th January 2026. Stop. Balance payment of the petitioner shall be cleared prior to the adjourned date. Stop. The receipt showing payment shall be produced before this court on the next date. Where is the proof to show that you paid?
That's not with me.
I have recorded your submission, and in case it is erroneous, then I do not know who is going to save your client. He'll be straight sent to the bar inside the jail for making false submission in court.
Then, my lord, allow me only 5 minutes now so that I might take back further instruction.
Then why did you say? Because he is saying that he did not get it.
My lord, so far, my lord, 5 minutes time, only one. I've talked with my.
All right, ठीक है.
5 minutes time.
As long as my officer remains. 5 minutes बोलबे. Yes, next 74.
For Lordship, I am for the applicant Lordship restoration application. Dismissed on 26 2019. Passed by Honorable Justice Vishwajit Basu. And a delay of 30 days, Lordship.
Delay of 30 days?
Lordship. Lordship, it's a changed brief, Lordship. The affidavit has been affirmed on 30th August, but in the office copy, the date is given 30th July. We didn't know. On 2024, the client came to us, changed brief, and while pursuing the matter, it has been informed to us by the department that it has delay of 30 days. Thereafter, we filed a restoration application, delay of 30 days. Can two, Lordship.
26th June, and this is 20th August.
20 June.
Yes.
And it has been filed in on 20th August.
Right.
But in the office copy that we have received, the date was given as 20 July. So we didn't know that it was filed on which date.
Yes.
We was pursuing the matter for listing, and it was intimated to us by the department that the matter
is August
by 30 days.
Right.
Thereafter, we filed an application for the condemnation of the delay, Lordship.
And what is the ground given?
Lordship, same ground, Lordship. I'm page 4, Lordship.
Ground for recalling.
Ground for recalling, Lordship. At the time of calling the matter, the advocate was not present in the court due to sickness, Lordship.
Sickness.
Page 11. Severe illness.
What is the matter about?
Lordship, the petitioner is a Group D staff in a Christian minority institution, Duff School. He was appointed in the year 1998. Thereafter, Lordship,
Who are you for?
My lord, Mr. Nilotpal Chatterjee is appearing, my lord.
For
please.
whom?
For the alleged contempt, my lord.
Contemptor?
Yes, my lord.
restoration application.
Yeah. 70 কত?
74.
74.
Dr. Chatterjee আছে কি?
আচ্ছা 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 oh, sorry.
Don't know anything?
No, my lord, I am not briefed, my lord, in this matter. Please. Sorry, my lord, this is institution.
Did you serve?
Lordship,
Whom?
Vinodpal Chatterjee and Cross State, Meeta
Yes.
Vishwas is appearing. It's my service.
my lord.
Lordship. Sir.
He is on his note, my lord. Can the matter be passed over, my lord, for some moment?
The service of CAN application.
All right, now what is the prayer in the writ petition?
Yeah, Lordship, my appointment was not approved, Lordship. In 1998, I was appointed initially the Christian Minority Institution. Then in the year 2008, DI directed another person who is a private respondent hearing for appointment from another school which is not a Christian Minority Institution. Now, subsequently in 2025, that person who was referred by the DI has died, and the notification memo was issued for fulfilling that post.
Yes.
That memo in the year 2025 is not annexed, Lordship. Lordship, kindly.
This is a writ petition of 2009.
9, Lordship.
So you cannot, there is no scope of annexing a document of 2025.
Lordship, that person who is inducted here is
Does the cause of action still subsist?
till 2000, till the death of that person, no legal appointment was given to that person also, who is the private respondent hearing. But when after the death of that private respondent, a notification was issued, a memo was issued in the year 2025 for fulfilling that post.
If the post is being filled up now, you can apply, and I do not know whether it will be eligible or what, but then what remains to be considered in this representation? To forthwith accord approval to the lawful appointment of the petitioner.
The petitioner has been working since then. Present situation, I have to take instruction. What is the present situation? The memo is of 7.
Let her make a fresh representation if required, we'll consider in accordance with law.
Fresh representation means the entire steps taken from 2009 will go.
Will not go if it is not permissible.
That is permissibility comes later on. Check up, you go through the brief. It's a 2009 matter.
Allow me to come back.
And I require the school. Please come.
Actually, handle.
ডিসমিসালটাকে রিকল করুন হ্যাঁ আর can one to both discourse
copy দিয়ে দিও
and let notice be served upon the non-appearing respondents. Waiting that the matter will appear in the combined monthly list of January 2026. Main. And both the applications disposed of. Order recalled.
We are grateful, my lord.
Yes.
Restoration application.
1 minute.
Well, they have sent a record, my lord, to her from they have sent to the bank authorities to for making payment, my lord. May I hand over the mobile?
That means payment has not been made.
Payment has already been sent to the bank, my lord, on 17th November 2021. They have sent me a record
to that effect, my lord. Possibly it has
Not
been already
yet.
disbursed to his account, my lord.
Not yet credited.
Till yesterday, it did not receive.
Till yesterday it was not there, and from 17th to today is 27th.
27, my lord.
10 days. It ought to have been credited in the account.
Obviously.
That means it has not been credited.
My lord, they have sent me to that effect, my lord, that they have already sent to the bank for making payment, my lord. That is their version, my lord. So, my lord,
যেখানে বললাম না ডিবি বাবু আগের ম্যাটারে পেমেন্ট হ্যাজ বিন মেড
sent to the bank, my lord.
রিলিজড হবে না, রিলিজটা হবে না, has been has been directed to be released in favor of the petitioner ওই 17 on 17, and the same will be credited in favor of the petitioner shortly. No. Have you followed how your client is misleading you? Not only you, misleading the court also. I'll take him to task and I'll keep it in mind.
No, my lord.
Next. Yes. For
restoration.
Restoration.
Delay of 14 days.
When was it dismissed?
Dismissed on 10th of April 2025.
Or 76th.
75.
Yes, ma'am. It's my matter.
75 was not called on. After 75, 73 passed over was
Mohan Roy.
75.
75.
Ah, you are 75?
76.
No, wait, 75 is going on. 75, when was it dismissed?
It was dismissed on 10th of April 2025 by Honorable Justice Raj.
10th April?
2020.
Petitioner
Earlier it was dismissed for default, restored. And second,
considering no necessary to give the matter, the same is dismissed for default. Yes. It was dismissed for default earlier also. And then, yes, again it stood dismissed. So repeated dismissals, how can it be restored? What is the matter about 2010 matter? Does the cause of action still subsist?
Yes.
What? If the petitioner is not interested, then?
No, the petitioner is interested. On that day, I failed to appear. My clerk failed to inform him that the matter got listed, and I just missed already affidavit exchange in between the petitioner and the respondents.
Yes. Petitioner is serving?
Yes, sir.
Right. Pay cost.
My lord.
Please come.
My lord.
The petitioner seeks recalling of the order dated 10th April 2025, dismissing the writ petition for default. Stop. Next. It appears from records that the writ petition stood dismissed earlier also.
Once.
The same was restored, and
after
on 10th April 25, it got dismissed once again. Stop. The writ petition was filed in the year 2010. And according to the petitioner, the cause of action still subsists. Stop. Next. The negligence on the part of the learned advocate for the petitioner to proceed with the matter cannot be appreciated. Stop. Next. The petitioner is directed to deposit a sum of rupees 5,000 in the office of the Bar Association, High Court, Calcutta. Stop. Let the receipt be produced before this court on the adjourned date. Released 18 December. 18th of December.
Get restored.
Not restored. Let the receipt be produced thereafter. Next.
Those restoration, since 2003, I'm pursuing this case, and I'll be
2019 matter.
it starts from 2003, the fourth round of litigation, First to writ petition, reason decision.
How, why did you permit it to be dismissed?
Other lawyers were there, it's not the reason.
11th of July. It is the same thing.
This can be disciplined. The suit has been decreed in my favor.
What is the
issue? Yes, The issue was the school in which I was working as an organizing teacher, there's a dispute in regard to the name of the school that has been recognized and the school I have named, Now, reason decision was passed that it is not the same school. Then that was challenged in the writ petition. Court said this dispute cannot be decided by the writ court. Go for suit. I instituted a suit. Suit was decreed in my favor and said that I am entitled to serve there. And thereafter, I made representation annexing that decree. Even thereafter, I was not allowed to. In the month of January, I will be attending 60 years. Next year.
That means you have not worked in the school.
I have worked, but I didn't get the benefit of my service.
When, for how long did you work?
From 1998
Till
2003, until the order was passed.
And benefit means what type of benefit? You didn't get the salary?
No.
No salary?
No salary. Because
98 to 2003.
I didn't get that benefit.
99, 2001, 2, 3, 5 years. For getting 5 years benefit, you are pursuing your case from
since 2003 to now.
You spend more than what you will earn.
That's the fate of my life.
What can be done? What is the use of pursuing this matter?
Now I am entitled to all benefits because of no fault on my part. I've been deprived.
Without rendering service, you want benefit. By serving at all, if I take your version, only for 5 years.
This is if your lordship fixes a date, I can satisfy your lordship. There are judgments.
Aside, what is the service that you've made?
Yes, there was a direction to serve upon the rest of the respondents, I have once again served, This is my every service. And yesterday I have mailed them also,
Who are you appearing for?
State,
What is your submission?
My lord.
Mailed IC West Bengal Board of
I have served through post and mailed them yesterday.
West Bengal Board of Secondary
Yes,
Education is a party.
The affidavit service, please.
The managing committee of one school is also a party.
Yes.
Does this school exist?
No. Yes.
Same plot.
Name has been changed. School exists,
Are you aware of the facts of the case?
Yes, my lord, according to my report, I'm submitting the report. Existing procedural application for recognition of the first considered Director of School Education.
Listen, the petitioner is not the managing committee of the school that the petitioner will go for recognition. He prays for his service benefits. Is the school recognized? Not yet.
In respect of recognition, my lord, Director of School Education. School Education based on view the Department of Recognition is granted by the board. Board is the authority.
Recognition has been recorded in the recent decision.
Whether the school is recognized or not, yes or no?
Board is the appropriate authority, my lord.
Sir, what does your report say?
Report says, my lord,
Who is the authority? The court is not inquiring.
as per my report, the report of the
Say yes or nay, nothing more than that.
Yes.
The school is a recognized one. When was it recognized?
2003. No date, specific date has been mentioned, my lord. May kindly fixes any date on the to be mentioned. I'll notice serve them once again, lad. Date mentioning করেন রেস্টুরেন্ট মেল করেছো হ্যাঁ
Where is your service upon the school?
হ্যাঁ সেটা তাই press report. My lord, I will come back with press report.
Where is it?
May I check?
I can see the receipt for the DI, secondary education, the secretary board, the oh, this is the secretary of the managing committee, Nimta. About 2025.
Recognition was given on 9th February 1998.
98. None appears either on behalf of the West Bengal Board of Secondary Education or the school. Stop. The
Recognition কোথায় বলুন
ওই দেখুন উপরে 9 ফেব্রুয়ারি 1998
লেটার এটা বোকার মতো কথা বলো লেটার না school in the later date
the
তখন স্যারের নাম
can I praise for recalling the order dated 2nd May 2025, dismissing the writ petition for record for default. Stop. The District Inspector of Schools, Secondary Education, Barakpur. It will be North 24 Parganas, isn't it?
Yes.
DI Barakpur.
DI Barakpur. Barakpur not to be 24
Barakpur,
Parganas.
Not 24 Parganas is directed to intimate the school that the matter will be taken up for consideration by the court on 8th January 2026. Stop. The school must be represented on the adjourned date. Stop. Let notice be served upon Miss Koili Bhattacharya, learned advocate, who usually represents the West Bengal Board of Secondary Education, intimating the next date of hearing. Affidavit of service filed in court today is taken on record. The instruction forwarded by the District Inspector of Schools, Secondary Education, Barakpur, dated 6 November 2025, be also written with the records.
Well, it's returnable on
Yeah, 8th of January 26.
any month in December. January is the last month.
It cannot be helped, sir. Next.
But only one thing needs to be cleared. This restoration is so far petition number 2 and 4. So far other petitioners, they are not given me power. Possibly they are not. They are no more in the world.
They have expired.
Possibly.
Who have expired and their heirs are not inclined. And so be it recorded that how many petitioners are there?
4.
The writ petitioner number
2 and 4 is pursuing.
1 and 3 have expired. Stop. The writ petition is being.
So far 3 is concerned, I don't have any information. 1 is expired.
The petition number 1 has expired. Stop. The petitioner number 2 is not represented.
Petition number 2 and 4 is represented.
2 and 4 are represented. Petitioner number 3 remains unrepresented. Next.
My lord, may I renew my prayer to take it up in any day on December? Is it possible?
The business of the court will not permit. Yes.
On behalf of the contender, my lord. And
Contemptor?
on behalf of the contender, it is my application for.
All right.
On behalf of the contender and affidavit was affirmed, my lord. I was to file an exception to that affidavit, my lord. It could not be done as yet. Lordship, I beg for only 1 week. File my affidavit.
This is regarding what payment
My lord.
has been made.
No, it is not. It is not made. And question of the contemners, they have opposed by an affidavit, and I was to file an affidavit in exception, my lord. I could not do it, my lord. Lordship, kindly give it 1 week time, my lord, so that I can come back.
And the reason for opposing is false billing and everything.
Everything. That is not admitted, my lord.
Please come.
Lordship, may I be given some time, only 1 week, to file my affidavit? Lordship, kindly takes up the order dated 18th of September. We have raised so many allegations, but those are not admitted on record.
Please come. Learned advocate for the petitioner seeks extension of time for filing an exception to the report filed by the municipality. Stop paragraph. The matter relates to payment of bills of the petitioner. Stop. The writ petition stood disposed of by the court on 3rd August 2022. When the submission of the municipality was that payment could not be made for want of funds. Stop. The court took note of the fact that the petitioner annexed certificates signed by the chairman and sub-assistant engineer of the municipality certifying that the petitioner completed the work as per the tender specification.
Yes.
Step. Relying on such documents, the court disposed of the writ petition, directing the municipality to take steps to clear the outstanding dues. Stop. Paragraph. In the contempt application, the municipality has annexed a note sheet signed by the sub-assistant engineer of the municipality that the memos relied upon by the petitioner were found to be fake and not genuine. The claim of the petitioner has been denied by the municipality. Stop. Under such circumstances, granting time to the petitioner for filing an exception to the report will not serve any purpose. Stop. Any claim, any money claim not admitted by the authority and rather denied and disputed cannot be adjudicated either in the writ proceeding or in the contempt. Stop. Next. In view of the above, the court is not inclined to proceed with the contempt application any further. Stop. The same stands disposed of. Stop. It will be open for the petitioner to approach any other forum, not other, any other competent forum for remedy if so advised.
Obliged to lose.
Next.
Lordship, I am for the petition.
Yes.
Your Lordship, the demolition order was passed. Till date, no demolition has been conducted. No compliance report has been filed.
Yes.
Lord, we have made partial demolitions, Lord. Thereafter, Lord, there is an application pending before the building tribunal. Though there is no stay, but it is not that we have not complied. We are on the verge of completing, Lord. We have done substantial demolitions. We will be.
Lordship,
doing the
nothing
rest,
has
Lord.
been done on record, Your Lordship. I must say they have just scratched a part of the wall, which they have further repaired, and now they
But
have
we can show the
further
photograph.
transferred the title also. And Your Lordship, last order of the writ petition passed by the Honorable Justice Gorang Khan, they have given 3 weeks time. If 3 weeks concluded, then municipalities were at their liberty to take any action as passed by the Honorable Court. Your Lordship, 3 weeks passed in February 25, Your Lordship. Till date, they are nothing has been. This is the government land, Your
Government land?
Government property, Your Lordship. This is the government land. They were the leaseholder.
The case is that the petitioner was a co-owner when the
No co-owner
started.
No ownership,
Lord,
Your
we do
Lordship.
not
This is
know whether it is
RA plot, Your
government
Lordship.
land or not.
This is RA plot, Your Lordship. They themselves are not aware. This is
No,
the
no,
RA
we are
plot.
not aware. We are not supposed to be aware. We don't have the rights.
এই যে আগের পাতাটা কমপ্লেন্সে যা এখানে দেখ 8টা ফ্ল্যাট ল্যাঙ্গুয়েজটা একটু ডাইসি 5টা
কটা বাকি আছে এত বড় বাড়ি +4 হলো।
You have the pictures?
Lord, we have the photograph.
The officials of the municipality, Bidhanagar Municipal Corporation made 3 flats at the 2nd floor, 3rd floor, 4th floor vacant. Vacant 3 flats, the stair room were demolished. 3 flats and the stair room was
No, Your
demolished.
Lordship, Your Lordship, kindly see, these were already vacant, and only the scratch in the part of wall has been done, which they have already repaired. This is the shop space, Your Lordship, not flat. This is this shop space, Your Lordship.
All right, next.
There are photographs where the ceiling has been brought
This
down.
is the shop space, Your Lordship. At the
Which floor?
basement.
Which
Basement,
floor?
Your Lordship.
This is the basement.
Basement. Ground floor, Your Lordship.
Lord, there is no basement so far as my instruction is concerned.
Your Lordship, this is the ground floor.
That means the ground floor.
Ground
maybe?
floor, Your Lordship.
Yes.
This
Lord,
is
there
the
are
ground
photographs
floor.
of the ceiling as well.
So your submission that nothing has been done is not true because some demolition took place. And I can see the ceiling also. The fan or something has been brought down.
Lordship, this was the shop
Lord,
space.
kindly see, this is the photograph. Lord. That is there also. Ceilings have been brought down. We are breaking it down from the top floor.
Please come. Peruse the action taken report signed by the engineers of the Bidhannagar Municipal Corporation on 14th of November 2025. Stop. It appears therefrom that the vacant 3 flats in the second, third, and fourth floors have been demolished. But there are still flats constructed unauthorizedly. Stop. The same could not be demolished as they were occupied. Stop. Paragraph. Hearing of the contempt application stands adjourned till 29th January 2026. Stop. The remaining unauthorized construction shall be demolished prior to the adjourned date. Stop. The police shall use required force for vacating the portions which are to be brought down. Stop. Further action taken report shall be filed on the adjourned date.
Only one sentence if it goes in, my lord. In the building tribunal, the petitioner has chosen not to appear. 3 dates have taken place and there is a refusal on the petitioner's part to accept service. That is the records which has been submitted. So, my lord, and the next date which has been fixed for hearing it ex parte in the absence of the petitioner is 2nd December.
Doesn't matter. I am not recording anything. Next.
Please, এটা ইয়েতে মেনশন করতে হবে।
79.
হবে না।
The petitioner, Lordship. The Lordship has passed an order dated 21st August 2025.
Yes.
Lions Orthopedic Hospital has taken an appeal against that order, Your Lordship, and this order was passed. Your Lordship would see para 21.
The order dated 22nd September 2025, passed by the Honorable Division Bench in MAT 1586 of 2025 with Can 1 of 2025 and Can 2 of 2025, party num, has been placed before this court. Stop. Does anything remain in the contempt after it has been stayed?
Your Lordship, if an appeal is preferred before the apex court, if this order is again set aside, then the matter will be restored to its original position. Then if Your Lordship would adjourn it, sign it, Your Lordship.
That is what the division has said, permanently stayed.
Yes.
Division has also said so in the for the
Yes,
time being it will remain stayed.
Yes, for the time being it will remain stayed. If this order is challenged, Your Lordship, then this matter will be restored.
হ্যাঁ সেটাই করে permanently stayed, that has been said.
Yes. This court, stop. On perusal of the same, the contempt application stands adjourned sine die. Stop. Liberty to mention.
Grateful, Your Lordship.
For the petitioner, my lord. It's a substitution application. Legal errors are before your lordship. 1st of May 2019, the writ petition expired. Writ petitioner, my lord, retired from service. No pension, nothing. Now twice moved this court. Ultimately, by order of this court, the authority was pleased to allow my lord provisional pension that he had been drawing. Now, my lord, he expired in the month of October, my lord, 25th of October 2024. Now, the family is in a helpless condition. The widow, daughter, and the son are before your lordship. So let them be, my lord, substituted and kindly fix any day because affidavits has already been exchanged.
25th
To
October
amend the first time, is there
2024
after to- is it filed in
November 24th.
so in time?
And I'm for the managing committee of the school. Managing
I'm
committee. of
filing
the
my
school.
affidavit of service.
The sole writ petitioner expired on 25th October 2024. Yeah. An application for substitution has been filed by his widow and children. Stop. The said application has been filed within the prescribed period of limitation. Stop. The same stands allowed. Stop. The department is directed to make necessary amendments in the first title of the writ petition. Stop. Let the writ petition appear for consideration in the monthly list of January 2026. Affidavit of service filed in court is taken on record.
Under heading, my lord.
Are all represented?
Yes, yes, yes.
State and the school?
My lord, school.
All right. Under the heading, affidavits are over.
Yes, affidavits are over, my lord. Only one day hearing is required. Few minutes that would be my service.
One
Because
day or 2 day will be something.
because the family is in a helpless condition without any money since October 2020.
Under the heading for hearing.
Or preferably at the top of your lordship, well, because
It is
the ladies in a helpless.
can take up hearing matters at all with the pressure of you. Why don't you try somewhere else? I give you the leave.
No bench is there.
No
Hearing bench at place.
classification.
As and when sit singly. My lordship sits singly. The lordships are in the division bench. Every day the lady is calling, "Ami ki khete pabo na?" I have no answer. That's the reason why I am
Then
pressing.
what can be done?
If it suits your lordship, can you fix a date in a supplementary list, my lord,
No,
to
nothing.
save the family?
Yes, 80. 81.
81, my lord, I am for the,
My lord, I am hearing the contempt.
my lord, this is my exception, my lord. Total 3 affidavits filed by the municipality. My lord, kindly have a look into the first, second affidavit dated 23rd April 2025.
What is the issue?
My lord,
Tell me.
my lord, matter relating to my lord illegal construction.
All right.
My lord, second affidavit, my lord, affirmed on 23rd April 2025, page 20. Total 3 affidavit. Second affidavit, 23rd April 2025.
21st April.
Yes.
23rd April. My lord, page 20. I am not troubling your lordship. Last line. During physical
Wait
inspection.
1 minute. Affidavit of compliance. One is 21st of August. Another I can see 19th of February.
21st August, third affidavit. 23rd April. 23rd April 2025. Second affidavit. Affidavit in compliance.
February one is first.
21st April. কি বলবো কোনটা বার করেছে পেজ নাম্বার কত পেজ কত
Page 20.
Page 20.
23rd April.
23rd April is not here.
21st April.
21st April is also not here.
21st April 2025.
Only
Kind level look. Kind level look.
19th February and the other is 21st of August.
Kind level look into my copy. My
No, no, you check up whether it has been filed or not.
We have been filed.
Let them see. দেখুন তো ওখানে ওইটা আছে কিনা. In the meantime, let it be passed over. Call on the next matter. দেখুন তো ওইটা আছে কিনা ইয়েকে দিন না. ওনাদেরকে দিন দেখে.
চেক করবেন তো.
See whether it's there. Call the next matter.
চেক করতে ভালো.
Pass over. 82.
PPO has been issued, my lord. PPO has been issued, my lord. Just now I have received the PPO. My lord, actually, my lord, it is issued on 26th November, my lord. My lord, till date, my lord, I haven't received any, my lord, amount, my lord. Though there was a direction, my lord.
PPO has been issued, so you'll get it step by step.
Yes. Certainly, my lord.
Please come. It has been brought to the notice of the court that the pension payment order in favor of the petitioner has been issued. Stop. Copy of the same has been handed over in court. Stop. The same is taken on record. Stop. Release the matter on 18th of December.
In the event, my lord, let there be directed to pay the, my lord. My
Direction, PPO
or-
issued means payment will
my
follow.
lord, order is
My
there,
lord,
my lord.
petitioner.
Because my lord was pleased to pass an order, my lord, to clear the
At
input.
presence, my lord.
Yes.
That order has been passed.
That order already is there.
Yes,
It's there.
that order is there, my lord.
18th of what?
My lord, petitioner required to the presence before the treasury officer. Certain formalities have to.
Formalities are
fulfill.
there.
Otherwise, no disbursal.
He is an employee. He knows what are the formalities. He will go.
Only prayer.
It is he who wants the money.
Only prayer before the lawsuit instead of 18 December after vacation lawsuit can be fixed.
Let it remain. We'll see what happens.
18 December, I have some problem. Lawsuit can be.
Let it remain. If the money is there, what is the use?
After reopening just lawsuit, I am meeting.
My lord, 207, my lord, similar matter, my lord.
207.
207.
That also PP has been.
PPO issue.
PPO issued, my lord.
Give the copy.
Yes.
207 একটা order record করে দেবেন, same order. 207, same order.
Aki, same.
Same appear.
Same appear.
Kept on the record.
Yes, yes. Give. রেখে দিন তো এটা রেকর্ডে রেখে দেবেন। এই যে,
এটা তো এটা
ওটা লিখে রাখুন 207.
Achi, yes.
Yes, call the next one.
Grateful, my lord.
83, my lord, this is my compliance report.
83, I'm led by Mr. Chittopriya Ghosh.
Petitioner?
Petitioner, yes,
Yes.
my lord, partly has been complied, not fully, my lord. My lord, unmarried, unemployed daughter paying for family pension of Swatantra Sainik Samman pension scheme under the. My lord, partly it has been complied with, but not fully, my lord.
Which portion has not been complied?
My lord, come to page 25, my lord. The order.
Of?
The order. Page 25 of the Contempt application. My lord, the second last paragraph, my lord. The respondent number 1 to 3 shall also decide on quantum of interest which shall be payable to the petitioner as the daughter of her freedom fighter father in accordance with the freedom fighter scheme. The interest has not yet been paid, my lord.
Has the quantum of interest been adjudicated?
I tell you.
No, my lord.
I tell you, Lordship, my lord, this part your Lordship has observed if it is provided in the scheme. Though our report is that there is no scheme. In the scheme, there is no provisions for paying interest. That is why it has. So Lordship kindly peruse the compliance report. Page 3, paragraph 5, your Lordship kindly.
Did you get a copy of the compliance report?
আছে তো এক্সট্রা আছে আছে এক্সট্রা কপি আছে আছে নেই হ্যাঁ yes.
Which portion?
Page 3, paragraph 5, your Lordship. The deponent states that the concerned respondent have acted in accordance with the direction of the Honorable Court and claim of the petitioner has been duly considered. It is further important to mention that the respondent issued the sanction of the pension to the petitioner by sanction order number such and such. It is pertinent to mention there is no provision to grant any interest on the payment of Swatantra Sainik Samman scheme.
The money that has been paid is from which period?
My lord, from 11
That
11 March 2018, my lord.
there is no dispute with regard to that. Only her contention is that interest, your Lordship's observation, if it is provided in the scheme, there is no provision in the scheme to grant.
What will be your submission if there is no legal provision in the scheme? How can the interest be paid?
My lord, actually, I'm unemployed. That's why, my lord,
Yes.
as
Please
your
come.
lordship.
Peruse the affidavit of compliance. Stop. it has compliance filed by the contemners. Stop. Learned advocate representing the petitioner admits receiving the principal amount of the
Along with interest cost, 30,000.
you've paid?
Yes.
Yes,
Uh,
30,000 paid.
স্বতন্ত্র সৈনিক সম্মান স্কিম ঠিক আছে it has been submitted that the interest has however not been paid. Stop. According to the contemner, comma, there is no provision for payment of interest in the scheme. Stop. Next. Upon hearing the parties, it appears that as the order has been substantially complied with and there is no legal mandate for payment of interest, accordingly, it cannot be held that the order has been violated. Step. Next, in view of the above, there is no requirement of proceeding with the contempt application any further. Stop. The same stands disposed of.
Grateful.
My lord, affidavit of service may be
Yes,
kept.
please. Service taken on record.
Grateful.
To appear on behalf of the petitioner, my lord, with a threefold prayer, we approach this honorable court. Prayer number 1 is, my lord, to stop illegal construction. Prayer number 2, my lord.
1 minute. What happened to the 408?
We have passed the order.
No, only passing order will not.
No, that the execution stage is going on. We are not.
Nothing, my lord. And my lord, kindly see, my lord.
I have followed it. Nothing.
Has been identified.
Wait, yes.
But my clients have, my lord, says when I'm giving a report. So instead of, my lord, making oral submission, what you
And
said.
copy to your learned friend. Let me see what is there.
ঠিক আছে একসাথে গেছে
Give a
দিচ্ছি
at least share it with him so
Yes,
that he
yes.
gets to know.
কত তারিখের রিপোর্ট
There are copies. Take it. দিন তো এটা ওনাকে দিন Yes.
They have demolished another building in the vicinity, not this building. This is my instruction.
Person responsible
They have not
constructed
touched this
four-story building without any sanction plan.
তোমার পেজের নাম্বার কত
Notice. ঠিক আছে।
হ্যাঁ
Column B.
Z3 236/8 Vidya Bagdipara Road.
What is the address?
Lord, kindly see the prayer portion of the writ petition. The address has been specifically mentioned as giving your lordship. It is, my lord, address not mentioned. It is mentioned as dag number 9, Khotian number.
That number will not do in the KMC area. How will they identify?
And my lord, the private respondent has been named and his address has been mentioned, their address as Z3 236/8 Bagdipara Road.
Yes.
This is their house.
Where is the unauthorized construction?
This house is unauthorized, my lord.
236 Z3 236/8.
Yes, my lord.
The report says, please check up that top 2 floors were demolished. 4-story.
Yes, ma'am. There's the premises number of premises on eastern side, number on eastern side of southern side Bagdipara Road.
Eastern side of, not this 236.
Well, I find, my lord, in the that's what I find, my lord, the top. It is mentioned, then I am to get it clarified. The premises on eastern side of southern side premises, that was the unauthorized construction which was detected possibly, my lord, is a Z3 254/4/A Bagdipara Road. Regarding that,
there may be several unauthorized constructions.
There may be, but my lord, of course, my lord.
About the construction.
Right, my lord. Let me, my lord, get it clarified because I find, my lord.
Please
that the order, demolition order, দেখি না demolition order টা কোথায়?
The petitioner
জানে নাকি?
complained of unauthorized construction over premises number Z3-236/8 Bagdipara Road. What number? 141? Borough XV of the Kolkata Municipal Corporation. Stop. The corporation appears to have taken steps under section 400 within bracket 8 of the AMC Act 1980. Stop. A report has been placed before this court, signed by the engineers of the corporation, mentioning that steps have been taken in respect of premises number eastern side of Z3-236/8 Magdipara Road within bracket premises number Z3-254/4/A Magdipara Road. Stop. The report mentions that 2 stories of the unauthorized 4-storied building have been demolished. Stop. From the report, it cannot be ascertained with certainty as to whether it is the construction complained of by the petitioner, with certainty whether it is whether the construction complained of by the petitioner has been demolished or demolition has been carried on in respect of some other unauthorized construction. Stop. Learned advocate representing the corporation is not able to answer the aforesaid query. Stop. Accommodation has been sought for. Released 18th of December. Further action taken report.
I'll get it clarified, madam.
The premises number which has been demolished be placed before the court on the adjourned date.
This building, they have not touched because.
And to the premises number down, let me get it clarified. Let it get it clarified.
There's an old widow lady staying. They are doing all these things with that lady.
Complete. Premises number, number.
Yes, clear, my lord, from your lordship's order dated 3rd July 2025, your lordship, my lord, observed that original affidavit of compliance affirmed on 23rd April 2025 has not been filed by the learned advocate representing the contemner, as the learned advocate on record of the contemner has undergone a surgery and is indisposed. A copy of the same has been handed over to the court by the learned advocate representing the petitioner for perusal. It appears therefrom that chairman of the municipal.
So 1 minute. It was given for perusal and then returned to you. So I do not have a copy.
Return me.
But now I have.
Second paragraph.
Oh, now you have filed. You made me search.
The second paragraph.
দেখি কি দিয়েছে?
Second paragraph, it appears therefrom the chairman of the municipality has come to a preliminary finding that the construction has been made without obtaining a proper sanction plan, and the chairman directed the person responsible to self-demolish the unauthorized construction within 7 days.
Wait, what are you reading?
From your lordship's order, 3rd July 2025. My lordship, kindly have a look into my exception. Today I file page 19.
What has happened? Has the demolition?
No, nothing. Thereafter stand, my lord, they changed their stand. As my lord, the private respondent is a poor, and my lord, small building, other no building. So my lord, change the stand. Kindly have a look into their third affidavit.
Your lordship, subsequently, there is an unauthorized, twofold allegation, they filed a writ application. One, it's unauthorized construction. Second is encroached the property of the petitioner, writ petitioner. Your lordship's pass order that the Arambagh municipality is directed to conclude the proceeding, pass a reason order and communicated the same to the parties. This is the order. Your Lordship disposed of the writ petition. Thereafter, my lord, after both the parties hearing that there is no encroachment, your Lordship then, my lord, contempt filed. There is also allegation that illegal construction. So for illegal construction, there is no, my lord, steps taken by the municipality. Thereafter, my lord,
Why are you not taking steps if illegal
after
construction?
hearing, my lord, after hearing, there is, my lord, there is no plan. That's why
No
your
plan.
Lordship,
No
yes.
That
no
means you
building
are
plan.
to.
Yes. Thereafter, your Lordship directed to is placed before the referred to the Board of Council.
Right.
Board of Council has already been, my lord, meeting was held.
And
Kindly,
understand.
1 minute. Meeting was held thereafter.
Page 29, my lord.
page
Third evidence.
29, Annexure A. My lord, it was filed on
Yeah, 21st
21st August 2025.
21st of August. Yes.
2025.
What
My lord,
is
page
this?
29.
29.
Kindly go through the board meetings. Kindly go through page.
Yes. What
Annex.
does it say?
My lord, kindly go through the
Which
second.
portion? Huh.
বালার সবাই ভরত পাখিরা আবেদনপত্র পেশ হইল, বিস্তারিত আলোচনা হইল। অবসহ বাস্তুকার আরামবাগ পৌরসভার পেশ করা রিপোর্ট অনুযায়ী আবেদনকারী ভরত পাখিরা যে একতলা বসত বাড়ি নির্মাণ করিয়াছেন তা স্কোয়ার ফিট 247। আবেদনকারী পেশ করা দানপত্র দলিল ও সংশ্লিষ্ট জায়গায় এলার পর্চা ও অনুযায়ী আবেদনকারী 2 শতক জায়গার দখলদার। পৌরবঙ্গ পৌর বিধি অনুযায়ী 47 অনুসারে আবাসিক ও শিক্ষা প্রতিষ্ঠানের ক্ষেত্রে ভূখণ্ডের আয়তন 200 বর্গমিটার ও 5 শতক পর্যন্ত 65% গৃহ নির্মাণ করা যেতে পারে। আবেদনকারী 2 শতকের মধ্যে 247 জায়গায় একতলা বাড়ি বসত বাড়ি নির্মাণ করিয়াছেন। উক্ত দলিলের সহিত সংশ্লিষ্ট নয়া নকশা অনুযায়ী 354 স্কোয়ার ফিট। অতএব আবেদনকারী যে একতলা বসত বাড়ি নির্মাণ করিয়াছেন তা 70% জায়গা অকুপাই করিতেছে। অতএব ডিভিয়েশন পরিমাণ 5%। ভরত পাখিরা একজন দরিদ্র শ্রেণীর প্রান্তিক মানুষ। ইয়াই ভরত পাখিরার একমাত্র বসত বাড়ি, অন্যত্র জায়গা বাড়ি নেই। সভাকে জানানো হয় এবং পৌরসভা কর্তৃক প্রেরিত নোটিশ মোতাবেক thereafter sanction plan was filed by.
Why don't you challenge this?
Matlab
What can the
illegal
contempt court do?
Matlab first evidence, matlab they are taking, my lord,
Diverse stance. I have
Lord,
forwarded
not only that, Lordship, kind level, not only that, my lord, Lordship, this is the authority.
Contempt application
Matlab,
is pending.
matlab, this
That's
is an,
why entire proceeding.
matlab, this is an, matlab,
Not only that, petitioner entire, my lord, building was
and it is an
unauthorized.
counter attack.
And also, my lord,
This is a counter attack, my lord.
second portion.
Matlab, contempt proceeding counter attack. Lordship, kindly hear me, my lord.
I cannot took steps, my lord, against the
Kindly hear me, my lord.
25.
Well,
Stop.
second evidence, they
therefrom
specifically state no
that
sanction plan.
allegation of unauthorized construction
house also knows.
was considered by the municipality and an order has been passed. Stop. The petitioner is aggrieved by the same. Stop. The court is of the opinion that the validity and legality of the order passed by the municipality cannot be adjudicated in the contempt proceedings. Stop. Accordingly, the same stands disposed of. Stop. It will be open for the petitioner to challenge the order of the municipality before the competent forum in accordance with law,
But,
if so
my lord,
advised.
chairman misguide the court, my lord.
Affidavit of
There are 3
compliance.
evidence and 3
Now,
stands, my lord.
Exception on behalf of the petitioner to the affidavit of compliance filed by the contemptor in court today be written with the records.
Yes.
Next. Huh? Rule chilo, rule discharged.
I'm for the petitioner, my lord. And I'm paying for 1 week time, my lord, because I have not received instruction from my client whether they have complied with the order or not. But learned friend says and show document it is in complied with.
I've already given the copy of the order to my learned friend, my lord. It has
So
been
my client
complied.
is concerned, it remains silent.
That means it has been complied. Had it not been complied, it would have been complained to you.
Maybe.
Order of demolition has been passed by the my lord.
All right. Upon hearing the submission made on behalf of the parties, it appears that the order passed by the court has been complied with, albeit at a delayed point of time.
Definitely.
So, paragraph. the the court is not inclined to proceed with the contempt application any further. The same stands disposed of. Next.
Grateful. Milord, I beg to appear on behalf of the alleged contender number 2, Milord. There is some adverse presumption has been made by your lordship, Milord, whereby I have been show cause. And the reason for this, Milord, initially the order was that there is a G+4 construction has been made and police was supposed to keep the strict vigil. This order was passed on 18 September
You
2000.
are the contender number 2.
Yes.
Who is he?
Milord, the Polish authority.
All right.
I just take your lordship to the Milord, the first order.
1 minute. Let me understand what it is.
Yes, my lord. The allegation is that there is an additional 2 floor has been constructed despite of lordship's order.
All right.
This is, I would say, my lord, incorrect statement.
Why? You were not aware of the court's order?
No, I am aware. I am following your lordship's order.
Alright.
The building was G+4 when this order was initially passed. So if the Milord suppose 2 other floor has been constructed, it will be G+6. I'll be showing to your lordship on the photograph. It is remain as it is. There is no other 2 other additional floor has been constructed. So this is, my lord, kind of.
When the writ petition was filed and the order was passed, it was G+4.
G+4.
And it is G+4.
It is remain as it
Where
is.
is the petitioner?
Milord, this kind of, Milord,
is the
affidavit,
petitioner?
Milord, possibly he is aware of this. He has made the long statement.
Lordship directed us to file show cause, my lord. I have filed the show cause.
Yes. Did you serve?
Yes.
Your show cause was also directed to be filed.
Milord, yes. So, Shokas, Milord,
And has it been served?
No, it has not been served because of.
Served. None appears on behalf of the petitioner. Stop. Affidavit of show cause filed by the administrator of the Bali Municipality and the
Milord, alleged respondent number 2, contempt number 2, sorry.
and the contender number 2.
It a copy আছে তোমাদের কাছে?
In court today be written with the records. Stop. Let copy of the same be served upon the learned advocate for the petitioner. Stop. It will be open for the petitioner to file exception to the same. Stop. Released on 29th of January. Next. 87.
For the petitioner, Milord, kindly see the order dated, Milord, 18 September 2025.
Yes. Where is the contender?
Milord, they appeared on the last occasion after.
Promit Sanyal. Order complied?
No, nothing.
What is to be done?
Even Milord, what happened? They applied for Milord construction. There is a civil suit pending. Civil court, Milord, rejected that application. Even without plan, construction is going on. So that my lord has taken note of that. Or kindly see, Milord.
Please call the learned advocate. Give a phone call. Samit Sanyal. Next, pass over.
I'm for the alleged contempt, your lordship. Several steps has been taken for recovery the gratuity amount and only the
appearing for the state, lordship.
For the state, it's a contempt matter.
Contempt matter. Good.
Are you aware of which matter he is appearing?
88, my lord.
88. Inquire once more.
Lordship, in this matter, lordship, several steps has been taken and gratuity amount has been recovered and thereafter only the compound interest is due. And in the meantime, warrant of non-payment of the compound interest, warrant of arrest has been issued by the certificate officer and thereafter, lordship, director was arrested, lordship, and it taken to the custody.
Taken in custody, but the payment has not been made.
Then, lordship.
Please come. None appears on behalf of the petitioner. Stop. It has been brought to the notice of the court by the learned advocate representing the
Alleged contender.
Who is the contender?
Petitioner. Certificate officer is the contender.
Which is this a municipality matter?
No, lordship. What is the Delta company?
Delta will be the private respondent. আচ্ছা contender লিখে রাখুন। That the director of the company.
Yes.
Oh, it is recorded. One of the directors have been arrested.
Yes, Lordship.
Then what new are you submitting today? You're not making any new submission.
No, thereafter
Certificate
another.
officer was directed to take steps to ensure that the dues of the petitioner are cleared.
Oh, thereafter three directors in this company, Lordship. One director prior arrested, and thereafter, after the warrant of arrest is issued further, non-payment of the only the compound interest, thereafter he was arrested.
Both two others.
Yes.
Two.
Yes.
Acha. Two directors have been arrested and are in custody. So, the payment of the gratuity amount.
Gratuity amount already paid, Lordship.
Then the
And thereafter on the compound interest.
The interest.
The payment of gratuity.
The compound interest on the gratuity has not been paid. Stop. Release the matter for further consideration on 29th of January 2026. Stop. 2026. Steps shall be taken to ensure payment. Prior to the adjourned date. Next.
My lord says that whenever the order will upload over the Supreme Court, my lord, that order is our. No.
SSC matter. রাখুন আমি দেখবো পরে. Yes.
Prime for the arrest.
Petitioner.
My lord has been complied.
Complied?
No, my lord, not yet.
No.
No, my lord, we have not gotten.
My lord, in payment of interest on delayed payment of gratuity.
Yes. How much have you paid?
18,000 off. He has received.
When?
2024. I have managed
24?
23 order was passed, 24
Huh?
I have paid.
No, my lord, as per my instruction, my lord.
Kindly come to page 4 of my
Interest has been
complaint.
paid as.
Give a copy. Affidavit of compliance filed in court is taken on record. Stop. It has been submitted that
Kindly comes to the communication, my lord, after the contempt,
interest
my lord,
on
after the
account of
contempt
delayed
notice, my
payment
lord,
has been
kindly
duly
see.
paid to the petitioner.
No, my lord.
All right. Yes. Which portion to come?
My lord, the contempt, after contempt notice, my lord, they have given a reply. That, my lord, if your lordship kindly comes to page 38.
Yes.
My lord, the second paragraph. So, in view of the above direction given by the Honorable High Court, Calcutta, in connection with CAN number such and such, you are requested to instruct your client to make necessary correspondence to the concerned treasury officer, that is respondent number 4 of the
Yes,
requisition
then what
to receive
happened?
the interest. My lord, the next page, my lord, if your lordship kindly comes. My lord, we have given the reply.
This is in
September
September 23. And according to the contemner, in 2024, payment has been made. Go through the affidavit of compliance and come back.
17 January
Let me-
2024.
Let me come with instruction, my lord. Let me
Yes.
come with instruction.
Paid. Stop. Learned advocate for the petitioner seeks time to revert with instructions. Stop. Released 8th January. Service is taken on record. 8th January.
Good.
Well, pursuant to your lordship direction, I am for the petitioner. They have passed a speaking order. I want to challenge this order.
All right. Learned advocate for the petitioner submits upon instruction that
That order has been
has been passed by the Srirampur Municipality on 12th August 2024. 24?
Yes, my lord.
Stop. The petitioner is aggrieved by the same. Stop. As it appears that the order passed by the court has been complied with, comma, the contempt application stands disposed of. Stop. It will be open for the petitioner to challenge the order of the municipality before the competent forum in accordance with law, if so advised.
Grateful.
Lord, in this matter, I had filed a review.
Mr. Boisho, how are you?
Lordship, fine. Now I am fine, Lordship.
All right, take your medicines.
No, Lord, I am take, Lordship. I am take care as per your advice, Lordship. As per your advice, I am taking to care to my health.
Petitioner. 91.
91, I'm for the petitioner, Lordship.
Yes.
Lordship, today we filed an exception regarding this review, Lordship. If it
This is a matter, my lord, where we had filed a review saying that the earlier scheme has extinguished. So we wanted to put these petitioner in a different scheme under the next finance commission. But so I have received something in the nature of an exception. Maybe the format maybe may not be permissible, but I understand what they want to say, that it was permissible to pay them under that scheme. So I have received it yesterday. I sent it to the department for some feedback on that. I have been primarily told that this is not the case, but I have no facts to apprise your lordship, my lord. So kindly keeps it after a week on the next application day, my lord, so that I can come back with the facts.
On the submission made by the learned advocate representing the review applicant, hearing of the application stands adjourned till 18th of December.
Lordship, can I file this exception, Lordship, regarding this review?
Regarding, please do.
Grateful, Lordship.
Affidavit, it will be.
Affect the exception regarding this review application, Lordship.
Why exception? It will be an affidavit, not an exception. The affidavit of the writ petitioner to the review application filed in court today be retained on records. This is the exception that you were talking.
Yes.
I thought your client had submitted some exception.
No, well, they have they gave me yesterday.
It's not an exception, it's an affidavit.
Affidavit, yes.
Yes, next.
Grateful, ma'am.
94.
I'm told that Mr. Sen is appearing.
Which Mr. Sen?
Amol Sen.
Yes.
On last occasion, he was here. He told me that he is appearing.
Where is he?
I do not know. Lord, here in this case.
In the absence of your other side. What was the order?
Lord, order, my lord.
Illegal construction over private property?
My lord.
Who is the
video, my lord?
Video.
My lord.
Why video?
Because, my lord, it is a
government property.
PMOI. Pradhan Mantri Awas.
Oh, Pradhan Mantri Awas.
Well, order already been complied.
All right.
Yes.
But an order, my lord, served upon me, my lord.
Yes, sir, please order.
Kindly see. I can appellate authority, so far my understanding. The direction, your lordship, my lord, very specific. My lord, before that, my lord, if your lordship kindly turn to page 22 of the contempt application. My lord's direction.
His cause of action already been arose.
You are the son or the mother?
I'm the mother.
All right. Any patch up with your son?
My lord, actually, he is not looking after me, my lord. I am, my lord, more than, my lord, 70 years. My lord, before that, if your lordships kindly permit me to file a short affidavit, my lord, which,
sorry, sir.
my lord, lordship kindly then, my lord, for a moment, my lord, for a moment. First page 22 of my contempt application, your lordship direction, and the order dated 3rd, my lord, October 2024. My lord, your specific direction, my lord, in the event it is found that the construction is made on the private land, in that event, the necessary, the illegal made construction of the building of the private land of the petitioner,
October 2024,
then necessary steps
passed by the block development officer.
My lord, only, my lord, give me 2 minutes time, my lord.
Taken on record. Stop. The petitioner is aggrieved by the same. Stop. It will be open for the petitioner to challenge the said order before the competent forum in
My lord,
accordance with law.
my lord, give me only 2 minutes.
Contempt disposed.
My
No,
lord,
sir.
only 2 minutes, my lord. My
Nothing.
lord,
95.
Hello.
95.
95, I am appearing on behalf of the contemners.
Yes. Petitioner, Monoranjan Jana.
My lord,
Has the order been complied?
order has been completed. Compliance report.
Compliance report.
My lord. 2 minutes.
Served copy of the compliance report? No.
No.
Compliance filed in court today is taken on record. आगे लिखिए none for the petitioner. Let the affidavit of compliance be served. Released 18th of December. Next. क्या था हम लोग देखिए 97 96 yes
But it's a matter I'm having to hold the municipality matter, but I'm not receiving any copy on contempt. The lordship please to drive it on the last occasion to serve a copy to the contempt.
it has been served upon your client has not forwarded it to you
As per my instruction, I have not received.
Sir?
Today, my lord, sir.
Has the order been complied?
No, not at all.
No.
Complied. He has admitted the executive admitted the construction is illegal, but he stated that the opposing party has the right to.
Let copy of the contempt application be served upon the learned advocate representing the contemptor. Stop. Released on 18th of December. Learned advocate for the contemptor shall come ready with necessary instruction on the adjourned date. Next.
ঠিক আছে আর কপি দাও আচ্ছা ঠিক আছে
97
Before Millard, for the Passover matter, Millard, we could not contact the learned advocate.
Not today, I'll keep it then. Or otherwise issuance of rule.
There is Millard 2023 order Millard.
Then rule to be issued. None of yours issue rule. Item number?
87.
87.
7.
CPN 860.
Rule issue. Returnable on 22nd January.
22nd January. Very
All right. Next.
requisites.
I have put in.
DDT.
Alice continue.
Same. The same council will be there. Are you there?
Mr. Banerjee is there.
For the contemptor?
Not the contempt.
Yes. Has the order been complied?
Mother, I don't know, but he is supposed to appear in the online.
Where is he? This Mr. Banerjee.
Shiv Shankar Banerjee.
Where is he?
Here. No. Last time he was here, but not today. He will appear online.
Item
Shiv Shankar Banerjee.
350.
350 to
354 or 5?
Yes, my lord.
4. Yes, where is the order has not been complied?
My lord, I don't know. I have no
You don't
instruction.
know?
I have no instruction, my lord.
What instruction do you have? Only to seek adjournment or what?
Not adjournment. Also.
Then what?
He
You are
told me
not.
that he will appear online.
Where is he?
Well, my lord, I am praying for short Passover. I am contacting him, my lord. Praying for short Passover.
Call the application one. 367?
I'm for the petition.
Yes, first time?
First time, my lord.
All right, serve. 29th of January 2026, it is returnable. 368?
My lord, I'm appearing for the petitioner. This is also first time.
All right, serve.
My lord.
369?
I am for the petitioner, first time.
All right, serve.
My lord, it will come up on 26th.
26th, not 26th, 29th of January 2026.
As application number, application.
370?
I am for the one.
Yes.
New.
All right.